Ms. Henry's present here representing herself. The respondent's present, represented by Mr. Valley. Mr. Valley, you have a motion.
I do, Your Honor, respectfully, and I'll be candid. I would be making this request anyway. I'm new to the case. Late last week, I'd say Friday. And there's a lot here. There's frankly a considerable history, and I'm not trying to score any points here. There's a considerable history. As the petitioner herself noted, there was a recent court hearing in another county, and even that shows that there's a history. The point I'm making is that my client is well aware. I told her that I would need to do this when we spoke last week. And for the court's information, I've represented Mr. Carrington, who is kind of in the middle of the triangle here. And that's how I come to represent Ms. Lewis. So she knows that the order will remain in place if the court grants the continuance, and I don't see any prejudice, while I recognize I am asking for a bit here because we don't come to court unless we want relief.
Sure. All right. And Ms. Henry, so Mr. Valley has made a motion to continue this case. What's your response, if any, to that?
I prefer to settle it today. She had 2 weeks to do it. And then she was also aware from our other court, which was like a month and a half ago, that I would be pursuing this order. Because previously I did a stalking order and only provided 10 pieces of evidence. Today I have 151 pages.
Let me sort of reel that back a little bit.
Yeah.
You said you prefer to settle it today. Does that mean you want to settle it by discussing it with Mr. Valley, or does that mean that you want the court to hear and decide the case?
The court to hear and decide the case.
So, okay, let's hold on. All right. So right now, the only issue I'm considering is whether it's appropriate to continue the case, not the merits of the case. Okay. So you heard what Mr. Valley had to say about why he wants the case to be continued. Do you oppose that? Do you have no position on that, or do you agree with that?
I'm not sure. I feel like it should be handled today because she had 2 weeks to do it. Sorry if I'm not understanding correctly.
No, that's okay. I just want to know what your opinion is on whether the case should be continued. It sounds like you don't want to do that.
No, because each time it's continued out.
So let me put it to you this way then. Typically, I'll grant continuances when attorneys join cases late. There are different reasons for that, but they have to do with the fact that attorneys have an ethical obligation to be prepared to represent their clients, and they can't just sort of be shoved into the middle of a case that's already in motion. They have to get ready for that. So in other words, Mr. Valley is new to this and you're not, so he has to bring himself up to speed. Normally, I don't think there's any reason not to do that, unless there's going to be some special prejudice to you and the ability to present your case. Now, you said you already presented a bunch of documents and other evidence, so we'll still consider those even if we have to reconvene on this case later. And as Mr. Valley said, the temporary order that the court issued before would stay in effect until that next hearing.
And Your Honor, I don't want to muddy the waters, but there's a res judicata argument here that requires preparation, which means I need to get all the documents from that case, which requires time.
Yeah. Okay. I think there's a good reason to continue this. I don't think there is any prejudice other than I know you really want to get the case heard. I completely understand that, but in this circumstance, it would be fair to just tell Mr. Valley, go ahead and do the case now.
Yeah.
So we're going to pick a date and keep in mind that the temporary order will stay in effect until then. We do these on Monday mornings, just like this. So do you have your calendar with you?
I'll check it.
Okay.
I can tell the court my Monday mornings are open.
Okay.
I generally a lot of times we'll have court Monday afternoon.
So why don't we start with looking at November 18th and go from there?
Yeah, that's fine.
Mr. Valley, is that going to work for you?
I will look just to be double sure. Yes, Your Honor, nothing comes up.
So neither party has to provide any further notice or service to the other. This will be sufficient, right? We'll see you back here November 18th.
Thank you.
Thank you.
366.
Your Honor, I'm going to go out on a limb.
Yeah.
This is not a domestic violence situation. I object to a domestic violence advocate or anyone else being at the table with Ms. Henry. I think it's part of a public relations smear.
Well, hold on. Let me get my files open and everything oriented before we start. Okay. All right. So, Mr. Valley, you have an objection to somebody being at the table with the petitioner. I see somebody is at the table with the petitioner. So, Ms. Henry, can you tell me who that is and why they're there?
Yes, it's my advocate. I've been working with for 4.5 years now.
Okay. And when you say advocate, you don't mean lawyer, do you?
No.
You mean something else?
Yeah.
Can you tell me what you mean?
Just my advocate that I've been working with.
So helping you in other regards, not with your legal problems.
Yeah, no.
Okay. Okay. And why do you need him to be here with you at that counsel table?
Just for emotional support.
Okay. All right. Mr. Valley?
And I said this with some trepidation because the harder you push back against. And the last thing I want to do is incur the ire of Your Honor or any court. I bring this in good faith for a very important reason. This is all a smear. And there's no showing and there's no nexus, to use the fancy pseudo-Latin word. There's no nexus between this. There's no showing. And it's also inappropriate to have anybody before the bar who's not a member of the bar. Thank you, Your Honor.
Yeah. Okay, well, let's see if I'm more concerned in the context of a hearing like this, whether it's disruptive. than I am anything else. People frequently have people at counsel table who aren't lawyers for various reasons. And I'm perfectly okay to allow it to happen as long as it's not disruptive.
Well, and I feel like I made the record and including the point that underlies it.
Yeah.
And it would be in the nature of a continuing objection if it was objectionable.
Yeah, I'm mostly concerned if people sit at counsel table who are acting in the capacity of lawyers and then trying to convince me through, artifice that they're not really, and they are, and I don't want to allow any kind of unauthorized practice of law, and I don't think that's what's going on here. I think I'm willing to let him, sir, sit at the table and, be of support, whatever that means, as long as it's not disruptive. Okay.
And Your Honor, just not to belabor the point, but I do intend to keep an eye out to see that I think any even whispering or offering of anything would be wrong.
All right. So let's take this case up with an issue that I have, and I think you may have alluded to it at the last hearing. One of my concerns, is that this case here in front of the court now may have been subject to prior litigation that resulted in a decision on the merits and in another court at another time. And if that's the case, then obviously it can't be relitigated in the context of this hearing in this court. But that may not be the case. It may only just look that way because the parties have been to court before, apparently, in another court. So can we address that?
Yes. So I'd like to clarify that Thurston County Family Court told me they weren't the correct venue for the protection order. And I attempted to turn in my protection order anyway to them in hopes it'd be pursued over there in family court. And I ended up getting an email stating they're not the correct venue for it. And then I also asked district court here if they could clarify with family court if this is a correct court. And then they called over and they said that it should be handled here at district court.
Okay.
So I attempted at family court. I turned in my paperwork and everything.
Yeah, that's similar to what I'm talking about, but not quite exactly the same thing.
Yeah.
Which court the case should or could be heard in is a slightly different issue than whether the case has already been heard before anywhere. Okay.
Yeah.
And just for your benefit, really, because I know Mr. Valley already knows this, but generally, if a case has been brought by one party against another and it's been heard in court and a decision has been made on the merits of that case, then that decision is final. And the only way that decision can be reviewed is through something like an appeal of that decision to a court that has appellate jurisdiction. So then it's not permissible to at another time bring the same claim against the same party in another court. Well, in any court, but certainly not in another court. Okay. You get what they call one bite at the apple. Okay. So that makes any sense to you. So if you have, and that's why I asked the question, because I've seen by looking at the history of you and Ms. Lewis-Oxley, so the parties in this case, I've looked at that history of there being cases between you, and I've seen on the statewide computer database that it looks like there have been cases. Some of them have been, or at least one of them that I was concerned about was a protection order case. And I do not recall now which court heard it. Maybe one of you can enlighten me on that, but I don't have my computer system up here.
I attempted a protection order in Thurston Tumwater Family Court, and I provided 10 pages of documentation. And then today I have 116 I've provided.
I may be able to access this.
Or I have 156 pages altogether.
Okay, I'll keep fingers crossed and maybe I'll be able to access that.
I can tell the court when that case was, and I have a case number too, but I'm also remaining silent until the court.
Yeah, I'm going to follow up with you in just a second.
It was due to insufficient evidence.
Do you have the case number of that case that you filed before?
Yes. 5734.
Okay, got it. That was a case in Thurston County Superior Court, May of 2023. Parties in that case are or were someone named Amari. That was a minor. And then there was the petitioner was you.
Yeah.
And the respondent was Miss Lewis Hoxie.
Yeah.
Okay. That's an area of concern. Let's see what happened in that case. Okay, so on, you tell me if you remember this, on June 28th of 2023, the judge presiding over that hearing issued an order denying the petition for a motion for protection.
Correct.
Okay.
Due to insufficient evidence.
Due to insufficient evidence, okay. Now, that's why I have a concern, because the material that has been submitted in your case, the current case that we have here in this court looks like it was dated around the same time as the hearings in the Superior Court case in Thurston County Superior Court last year.
I provided stuff from 2014 to 2024 and many updated declarations as well. There's 12 declarations. So it was a total of 10 years of this stuff going and not stopping.
Okay, so the material, let me ask it to you in a slightly different way. The material that you submitted for this court to consider in whether or not to issue a protection order, have you previously submitted that same material to another court in another hearing?
She attempted a fraudulent order against me randomly.
I need you, but I know that you probably want to say a lot about the circumstances, but just let's zero in the focus a little better.
That's why I'm bringing it forward for an anti-harassment order, because the other judge did not see all of this. No, she only had 10 pages.
10 pages.
Yeah, that I turned in. And today I have 116 and of 156 altogether.
I think that answers the question I had. I mean, there's a lot here and not all of it's dated, so it's hard for me to know.
What wasn't dated? I'm sorry.
Well, a lot of this is screenshots of texts and things like that. They don't have dates on them. So just looking at the documents themselves, it's not possible for me to say when they were generated or when they may have been submitted before. All right, Mr. Valley, can I hear your take on this, or I guess an answer to my question about previous litigation?
Yes, first I'll just note we spotted this issue as the court noted. So I have clear thoughts. It's just where to start. This case that the court just reviewed, the finding, the denial or the dismissal, that happened in June of 2023. So my argument is that anything from 2023 is res judicata. And my argument further, getting into the facts, as in the nature of an offer of proof that Ms. Henry has made, there's only one incident since Thurston County Superior Court dismissed a petition using the same evidence from 2014 to 2023. And I want to make this subordinate point or parenthetical point. To say I only gave 10 pages of evidence is to beg the question. You shoot your shot. That was batting practice. To allow someone to submit 10 pages of evidence, not succeed, and then submit 150 pages of evidence would be to allow batting practice, which we don't. That's exactly res judicata. But that's a parenthetical point that I presume the court understands and appreciates. So there's only one incident since June of 2023, and that's the encounter in the mall that amounts to nothing. It's an encounter, as I advise my client, and maybe I'm wrong, but I said, you should be able to flip somebody off in the mall. And I know that's crude and rude and socially unacceptable. But if the worst it got was mean mugging, and also I want to note something else that's drastically, I'll stick to the res judicata. What I was going to get at, though, was there's an underlying family law, and this is an end run around that. Amari is Ms. Henry's and Ms. Lewis's significant other's child. Verna Henry and Brandon Carrington are the parents of Amari, who's not seen his father in a long, long time. They had a settlement conference the day of our last hearing in this case, at which nothing, I'm not the lawyer in that case, but Ms. Henry's position is entirely positional, which negotiation 101, positional negotiation is the second to the least effective. So this is an end run around that. My final point is, and I'm going to be intellectually rigorously honest, as I always try to be. If I ever make mistakes, they're unintentional on my own. So this is a stack of far more than 10 pages that Ms. Henry filed, not as the petitioner, but in response to Ms. Lewis's recent case in Mason County Superior Court that the court denied before Judge Cobb denied. And anecdotally, my client told me he told these people to stay away from each other. Verna Henry lives in Lacey. Tia Lewis lives at Skokomish. They could not be further away. Yeah, of course they could, but my client would have to live in Brennan and Ms. Henry in the Nisqually for them to be further away and remain in the same counties they're in. So it's res judicata except for the August 2024 encounter at the mall, which does not arise to even a prima facie showing of harassment. So and now I'm getting all worked up, and I apologize for that to myself and everybody else, because it's much more effective advocacy to be slow and come up as if we were under the floor. So that's what I want to do. I think a res judicata dismissal is appropriate. And I didn't have time. I keep promising my client, I think this amounts to, and I don't even know the phrase, but the anti-slap. If I had had more time and more resources, I would have researched how I can proceed with my client to see to it that Ms. Henry stops this. Thank you, Your Honor. And also, there are two sides. I mean, everything she says, we can say back. Except for I think we have stronger facts in our case.
Okay, so the case you're referring to in Mason County, also between Ms. Henry and Ms. Lewis Hoxie. In that case, Ms. Lewis Hoxie was the petitioner and Ms. Henry was the respondent.
24-2-6-61-23.
Okay, I've got that case here. And in that case on September 27th, the judicial officer, not identified, entered an order denying the motion for protection order.
Yes,
so
absolutely.
It looks like that was the same outcome as the Thurston County case the previous year.
And I could say I don't know why we're here, but I do. We're here because of Amari.
So,
and there's no allegation even, except for Amari was at the mall with them. But any of these to 2014, Amari is a collateral damage, but he's also the driving force. It's a 6-year-old boy wagging the dog.
Right, Ms. Henry, here, my concern is, as I've said, that this case has been heard before. Okay, just to keep it as sort of straightforward as I can say it. And Mr. Valley's correct. Even if you went to court before in Thurston County Superior Court and you gave the judge there 10 pages of information that supported your position that you should have a protection order, and the judge listened to all that, listened to what you had to say, listened to what she had to say, made a decision and decided, no, I'm not going to give you a protection order for whatever reason, sent you out of court with an order saying, no, you don't get a protection order. You can't then go, gosh, there's a whole bunch of other stuff I should have told that judge and I didn't. Okay, there's way more information that I wish I had brought, because I'm sure the judge would have made a different decision had she known that there was all this other stuff. And so you get all that other stuff, put it together, get how many pages it is, how many pictures or text or whatever it is, and you put that together and go back to the judge and say, Judge, I know you just decided against me, but here's all the other stuff that I wish I had given you that if you had known about, you would have made a different decision. Okay, you can't do that.
So could we consider 2023?
Well,
June and up
here's what
since
we
it's
can
not
consider. We can consider stuff that has not been litigated before between the two of you. That includes not only the information from the Thurston County case where you told me you submitted 10 pages, but also probably the the hearing that was conducted in Mason County in September of this year. Okay. That may or may not be 100%. That's a slightly different issue. But what I'm saying is, if it's new, you can present it here, right? If it's new.
Yeah, and I have that.
So in your estimation, what I'd like to do is have you identify for me what's new. And then I'll consider that, the new stuff. And the new stuff may or may not justify issuing an order. I don't know. I'll hear from you, and then I'll hear from Mr. Valley on Miss Lewis Hoxie's behalf and make a decision. But what's new from what was submitted to courts before?
So Miss Lewis has been coming to our home, banging on our door, and she has threatened my daughter and then tried to grab my son. We've had to relocate. And the previous landlord, I've provided proof of her knowing and aware of the safety issue, as she attempted to help us break our lease to move. Safety locks changes. And then they accessed my address illegally since I was signed up for TANF. Her mother-in-law works for TANF. Her mother's supervisor has an email. I'm included as well. And then the same month, Miss Lewis was asking for a protection order, a picture of her vehicle at her house, and a picture of her still bashing me on social media. The same month she asked for a protection order. And then the same month as well, I provided a screenshot showing her saying, working on my sucker punch, still got a ways to go yet. And then this is Brandon's ex-baby mama, if you know, you know. There's other people who have also shown up to my home.
Your Honor, I'll object. I don't think any of this is new, and there's not been an offer that it's new.
Well, I'm following along here.
It's all
If
dated.
the declaration that she submitted in her petition is the same information that she's telling me now, this is all in the record already.
All this stuff from August. And then I also have witnesses who have seen it, neighbors as well. And then I also have someone who always drives with me everywhere. So I have a witness to any assaults or harassment.
Yeah, you filed declarations to that effect too.
This is the only time within the last 4 weeks where she has not tried to assault me, show up to my home, or threaten me.
Your Honor, that's perjury. I object, and there's no foundation, no basis for that. I know it just came out of her mouth, and that's also news to us, and there's no basis for it.
Yeah, I'm looking here in the declarations that Ms. Henry filed, and I don't see allegations like that.
This is all out of whole cloth, Your Honor.
No, this has been going on since 2014. I was 14 and Miss Lewis was 17.
And I'm going to
now
object to
25.
the, I know, I wrote it down 10 minutes ago when she said this stuff has been going on for 10 years. I object, and I know the court can separate the wheat from the chaff, but I object to the use of the phrase, this stuff. There is no this stuff. And that creates momentum and becomes a snowball. And that's why I object at the very beginning. This is all a smokescreen, including the DV advocate.
I've been assaulted 7 times.
I object and ask for some offer of proof.
I've provided one.
That's not race judicata.
Directly from Miss Lewis.
So this is a good example. You told me that you've been assaulted, and I assume you mean by Miss Lewis Hoxie.
Yes, and
Okay.
she also has her
And
phone.
so when? And then point me to the place in your declaration and supporting materials that refers to that talks about that.
I've also here. In my declaration, it states, I have endured 7, almost 8 assaults attributed to Miss Lewis.
As part of your declaration.
Yeah,
When did those assaults occur?
all throughout the years.
See, that's a little bit about what I'm concerned with. Because when you, and without even evaluating whether it happened or didn't happen, okay, just putting all of that aside, if that's been brought in front of a judge before, and then the judge rendered a decision, okay, the judge decided, in Thurston County, the judge decided a year ago. In Mesa County, the judge decided in September. And the important thing is that if this has been heard and a decision was issued, regardless of anything else, I can't then hear that as if it's a brand new case and make a decision on it.
Even though I turned this in to show Mr. Cobbs like why her order needed denied and was fraudulent.
Yeah, that's when Mr. Valley, you may have heard him say the words "res judicata." Okay, that's one of those legal principles that kind of stays with us all the time in the law. And even though, you know, I don't expect you to know it, and it's not your fault. There's no, you know, no criticism is being directed at you for not knowing that. That's something that people go to law school and spend years studying, and books are written about it. Okay, don't get too bogged down in that. I just want to make sure that you understand it this way. It's like, it'd be like a sporting event, you know, where parties, you know, two different teams played a basketball game or something like that. And then one team wins, one team loses. You know, there's a referee in the game, and the referee made a bunch of decisions about whether the baskets were legal, whether fouls occurred, all that sort of stuff. And then, you know, afterwards, the team that lost the game looks at all the tape, you know, and the video and says, well, that wasn't really a foul that we got called, or there's a foul that should have been called in our favor. That basket wasn't legitimate. It shouldn't have been counted. It like that, right? And if you look at all of that and you think, gosh, we should have really won that game because there were some bad calls in there, or there was some, you know, there was some cheating that the refs didn't see. You know what I mean? Things like that. You can't then go back to the refs and say, see this video of the game. You have to call the game a different way now and award the victory to my team. That's sort of what I'm talking about, only in the legal sense. It's that was an analogy, just so that you could see that once it's done, it's done. Now, in your case in front of Judge Cobb, or your case here in Thurston County last year, if you didn't agree with the outcome, if you came out of there and thought the judge made the wrong call, there was good evidence in my favor that the judge didn't consider correctly, or the judge didn't allow me to present evidence into the record that the judge should have, then you can appeal that decision to a higher court, and a higher court can look at that and they can review it. And if they agree with you, they can order the original judge to do it again. But it appears from the record here that you didn't do that. Instead, what you've done is you've filed a new petition with many of the same allegations in it and brought it to this court. That's what you can't do. And I had that concern from the very beginning when I looked at this case.
So if they don't take this at the family court, how am I supposed to get it? Since they said insufficient evidence and I provided them.
When they heard the case before you, when the judge said that the evidence was insufficient.
So when me and my children aren't safe, what are we supposed to do?
Well, here's what I could say about that. If you don't feel safe, first and foremost, you can call 911 for law enforcement protection. Don't even consider whether there's any kind of a no contact order, protection order. It's irrelevant. If you don't feel safe, you call the police. They will come, and they will tell you that they would rather come and not be needed than not come if they were needed. So you do that to protect yourself for sure, regardless of what I tell you here about protection. And then what you can also do is, if you believe that you have been the victim of harassment, stalking, domestic violence, whatever, you can go to court and you can ask the court to issue a protection order. I am absolutely not telling you that you can't do that. I'm just telling you that if you do it and the judge makes a decision, that's the decision. Okay. And it's not subject to just bringing it back and asking a judge or even a different judge to look at it again. That's the law just doesn't allow for that. And I think, and this is where I'm willing to be wrong in the sense that if I misunderstand, tell me. I think you have been heard previously on this issue. And I can't offer you another opportunity to be heard again. What I can do is offer you an opportunity to be heard if it's a new case, if it's genuinely a new case, something that has arisen from acts and circumstances that were not known or didn't happen before. If it's new, we can hear new. That's okay.
And that's what I provided to Mason County, which is why her order got denied. All of that was new. None of that was in the previous case.
Can you separate that out from the other stuff that you filed in this case
I
so
can
that
do that.
I know what it is you're alleging is new that hasn't been heard by the court before?
I can do that, Your Honor.
Okay. Is that something that you can do now, or is that something you need some time to do?
I'd be willing to do that right now.
Can I call another case while you do that? And then I'll check back with you and Mr. Valley afterwards, and
Yes.
we'll bring you back up here?
Yeah.
Okay. Are you willing to work with Mr. Valley on and show him what you think the new stuff is?
Yeah, that's fine.
Okay. Why don't you do that, and we'll call your case up again.
Thank you, Your Honor.
All right, Ms. Henry, were you able to kind of sort and identify what information is new?
Yes, I removed all the pages that were included from my first stalking order at a Thurston Family Court.
Mm-hmm. Okay. All right, and did you share that with Mr. Valley then?
Correct.
So that he knows what you're alleging is new versus the information that's been heard before by a court?
Yeah.
Okay, and did you receive that, Mr.
I
Valley?
did, and it's not, nothing happened, Your Honor.
Okay, so what I'd like you to do is present that to me so that then I can see what the allegations are that are new.
Okay. So in the paperwork submitted, which was the persistent harassment and threatening actions, my doctor's notes from when Ms. Lewis attacked me. And it shows the other witnesses and declarations of when I was assaulted.
Do you have it there with you
I have
in
it
hard
all
copy? Can you just hand that to me?
Yes.
The new stuff, not everything, but
And Your Honor, nothing, what I meant by nothing has happened is all she did was take out, and this is what she took my notes, remove the 10 pages previously submitted.
Mhm.
So the facts are all still old.
Okay.
And to make this record clear, and I think the court has already intimated exactly this, I can't defend against this when it's a constantly moving target. So I'll leave it at that.
Just from her previous or my previous order of June 2023, I still have multiple pages, at least like 64 in the last year.
Okay, I think you've just handed me all of the same material that was in your petition, the whole packet, so to speak. I have that in electronic form.
Yeah, I submitted everything that I took out all the paperwork from my previous anti-harassment order. It's in my purse.
Okay, so I won't need this hard copy. I can just hand that back to you and you can continue to use it there at the table. That's okay. All right, so I have seen and reviewed all the material that's been submitted by both parties, declarations, supporting exhibits, everything. So what I'm going to do is I'm going to decide the case based on those. So I'm going to give you, Ms. Henry, the first opportunity to argue to me based on the evidence that's already in the record, why you should get an anti-harassment order in this situation. And then after I've heard from you, Mr. Valley will present his argument on Ms. Lewis Hoxie's behalf. And then I'll make a decision as to, is there going to be an order or is there not going to be an order? And I'll explain to you why. Okay.
Okay, thank you.
All right. So Ms. Henry, go ahead.
Do you mind if I read from a paper? So I don't
You can, but keep in mind, it's already part of the record in the case. You don't it's okay to call my attention to it and point out passages
Just
and
not the
things
same
like that. You don't really have to read everything.
Okay.
But I'll leave it to you.
Okay, Your Honor, you will notice my order was dismissed in June 2023 due to insufficient evidence, as I only turned in 10 pages. Today, after removing the other pages, I have 109, and then about 64, just including from the last year, from June 2023. Many of the paperwork documents show the assaults, threats, harassment, and witnesses towards myself and my family. This has been consistent from the age 14 to 25. And Ms. Lewis stated she will be a witness in trial and that I was aware she will be, but court records at family law and my PO box will show I've not been provided that information whatsoever until she just mentioned it today. I was not served any documents she's turned into court. I had to view them online this morning. Ms. Lewis also stated of multiple protection orders, which is false, and the court will see that I have one protection order against Brandon Carrington due to domestic violence, which was extended to 15 years. Ms. Lewis' claims are irrelevant to the fact that my family and myself deserve to be free from Ms. Lewis and her people showing up and banging on our door, threatening us out publicly and at our home, and taking personal photos of us and our names bashed on social media, as well as the fraudulent information spread by her and provided to a recent court, in which thankfully that was denied, in a separate county in which none of us reside, as all of our stuff has been heard in Thurston County. The judge clearly stated she mentioned many irrelevant things, had known many people from our declarations due to their past incidents, and how the harassment does need to stop. That's the third time the court has recommended Ms. Lewis behavior halt. By me pursuing this order after her fraudulent anti-harassment order and documenting years worth of continuous dangerous and concerning behavior towards me and my family could never be in bad faith, asking for our safety from her harming us or our home or our vehicles. I'm hoping we'll be able to enjoy our activities with our tribe and with other friends and family instead of having to be fearful and avoid certain areas, such as certain areas in Thurston County and Mason County, just so we don't bump into them. No child deserves to be followed or made uncomfortable in their home where they feel compelled to relocate just to feel safe. No child deserves to think they will be taken away because of threats and inappropriate things being said by Ms. Lewis to them. I would like to make it known that I've always reported and documented many of the unsafe and harassing incidents for Ms. Lewis. Some of the documents to name and provided are a guardian ad litem report showing concerning and dangerous behavior in which the visitation facility workers would walk my young child and myself to our vehicle. Guardian ad litem also stating she's seen the physical evidence of Ms. Lewis threatening to harm me. Mason Clinic documentation from the doctor when I was assaulted by Ms. Lewis when she showed up to our private property with multiple people.
Your Honor, I object. This is all old.
Paperwork from Ms.
I'll note the objection, but I'm
Thank you,
gonna
Henry.
let her continue to.
Understood. Thank you.
Paperwork from Ms. Lewis herself stating false intel to police that I am a known aggressor, which, as you can see on my record, I am not whatsoever. She accessed my confidentiality address and a false number provided through TANF previously. I'm a part of the confidentiality program, so they allowed me to not use my current phone number because her mother-in-law works with TANF, and I included that documentation from her mother-in-law's supervisor, Mickle. And I have proof from my landlords attempting to help us break our lease in order to move. I provided documentation for my child supervised visitation at a facility, stating he was hiding from Ms. Lewis when we were in the same store. 12 declarations of the few people who have seen the ongoing assaults and harassment. Your Honor, if you put my anti-harassment order from the past and previous and my serious concerns in my declaration side by side with Ms. Lewis, you will notice her statements change drastically and directly copy what I have said in mine. Things such as her impacting my career, as I've had to move my job 2 times and I'm working towards college in a 3rd career, and that was almost put on hold due to her fraudulent order. My family deserves peace and to not live in fear. We've taken serious measures to avoid harm. We've relocated 3 times. I've worked with Advocate a total of 4.5 years, in which they've helped me and my family with the security system, hotel stays to avoid harm.
Your Honor,
And
this
then
is
they helped me
irrelevant. I
with the PO
object.
box, so I wouldn't be harassed by Ms. Lewis and her mother-in-law at my home. I stopped being allowed
I
mail there.
object. No foundation to harassment by anybody at her home.
I'll note that and you continue. Go ahead, Ms. Henry.
Miss Lewis feeling the need to correct me for writing my children's last name and me wondering how she'd possibly know them shows the stalking's nonstop, and it's concerning how obsessed she is to the point she feels the need to search that deep into my children's privacy. There's no way she'd know my children's last name. I'm not understanding. In her previous order for her anti-harassment order, she stated I'm a drug user and that I'm a gangster, which is not true at all. All of this has been one-sided, Your Honor. I have never tried to reach out to her. And I believe Ms. Lewis recently stated she worked in childcare since our last court date in order to avoid the anti-harassment order being granted in order to make her look better. I would like to see proof of her start date because that will truly help show she will do anything to manipulate the court system. Your Honor, I go nowhere alone, and I always make sure to have a witness and do my best to avoid being harmed and harassed. My children and myself deserve to feel safe and comfortable in our home and in outings again. I kindly ask if you help me by not allowing Ms. Lewis' persistent and obsessive behavior in which bring harm to my family. By putting most evidence I have forward, I hope it shows I have responsibility to protect my family from these outings. Ms. Lewis has orchestrated attacks against me, a fact she has openly acknowledged on social media and screenshots I've provided from Ms. Lewis's Facebook on multiple
Objection,
occasions.
that misrepresents the facts, Your Honor.
Knowing my
Yeah,
children
no,
are always
noted.
with me and the
You
risk of harm
continue.
to them that has been done. The photos provided also demonstrate Ms. Lewis and her accomplices engaging in harassment, threats, and defamation on social media, as well as making false threats, including involving CPS, physical assaults, and
Your Honor,
disparagement.
she's going on and on. She got 3 pages left, single spaced, like 350 words per page. And she's added nothing. She's added no single fact. This is all conclusory argument.
Despite my efforts to avoid confrontation.
That's an objection, Your Honor.
Yeah, hold on a second, Ms. Henry. Ms. Henry, what I want you to do here is essentially sum it up.
Mhm.
I'm familiar with all the allegations that are in the record. In other words, the statements, the pictures, the social media posts, all the things that you've already put in there. They're all there. I know you want to say them again because they're important to you, but it's not necessary for you to do that because they're already part of the record. So you don't have, it's not adding anything to your case to say them again, but what they mean and how the court should interpret them and apply the law to decide whether or not to give you a anti-harassment order. That's the part that you should be doing now.
Okay.
And if you don't want to add anything else, you don't have to.
Okay. With the documentation turned in, it is evident that Ms. Lewis has committed multiple offenses, including a hate crime, telephone harassment, first-degree criminal trespassing, first-degree malicious mischief, stalking, cyber harassment, coercion, reckless endangerment, and harassment. Thank you for your attention on this one.
Thank you, Ms. Henry. Mr. Valley, you want to sum it up for Ms. Lewis Oxy?
Please, Your Honor. First, and again, I don't want to be counterproductive and harm my client's case. When I say I would move the court dismiss this for unclean hands. The court caught Ms. Henry in a blatant lie in the first session when she said that this is the first time, this last week is the first time that my client hasn't attempted to harass her. And she had more or less, through her silence, admitted that was a lie. She lied when she said that she had never reached out to my client because the first document, and there was an acknowledgement and there was not a request for continuance. I did read the local rules. My client didn't get her stuff in 5 days ahead of time. And that's as much my fault as it is hers, because even though the court gave us 2 weeks, that time ran very quickly. No excuse, because there was no objection to it. The first document that my client submitted gives the lie to Ms. Henry's lies. It says, "What's up, bitch? Keep posting Amari's," one could assume she means name or visual face, "and see where it gets you. You're being," and I want to emphasize again, this is Verna Henry to Tia Lewis. "What's up, bitch? Keep posting about my son and see where it gets you. You're being watched, and don't think any of us forgot where you live." This is a woman who says this woman's been harassing her for 10 years and also lied and said she'd never reached out to her. And there's much else that shows that Verna Henry's lying. And I know those are harsh words, but I had to sit here and listen to calumnies heaped on my client and they're all false. For instance, I'm not as familiar probably as the court is with all these exhibits, but I know there's one social media post where my client did say something about Verna Henry, and it's not harassment. But what is harassment is you're being watched. Don't think any of us forgot where you live. Think twice. This is still Verna to Tia. Verna, who says she never contacted Tia. Verna, whose petition I'm asking the court to dismiss because of bad faith, because of unclean hands, because everything she said to the court is either a blatant misrepresentation, a blatant and intentional misrepresentation, or an outright lie. Because she said she never reached out to my client, but she sent this, and I'm continuing this single Facebook message. Think twice before you cross me, because this is a death threat. This is felony harassment, and my client had good reason to believe she would carry it out, especially in the context of this message alone, because it ends with sleep with one eye open, bitch. And I'm giving emphasis to the cuss word that this woman threw at my client. And I'm going to go back to the middle of it. Think twice before you cross me, because next time will be your last. Again, death threat. And I'm going to interrupt myself. Ms. Henry, without any basis, talked about a hate crime, talked about cyber crime, talked about stalking, talked about assaults. There's no evidence that Ms. Henry ever called the police. I know that once this woman's significant other broke Ms. Henry's windshield with his left hand. And that's where she says she got a 15-year restraining order against him. I don't think there's any such thing as a 15-year restraining order. My client tells me no, that it didn't. It did get renewed after it expired. And I represented Mr. Carrington at some point, but Ms. Henry didn't even call the police then. She's never called the police. So you can't believe a word she says. But I want to finish reading that text message. After the death threat, it says, I'm so sick of your ugly ass acting like you won in life. Brandon, who is her ex and her current, Brandon never wanted you. This is intentionally hurtful behavior. Brandon never wanted you. You have him because he was left. You have him because I left him. That's what Verna says to Tia. So funny to watch you guys play house. Just leave my son, and I'm adding that word, those two words, my son. Just leave Amari out of it. Sleep with one eye open, bitch. Now, see, here's where, again, more bad faith, more unclean hands. This is an abusive process, because what this is, in her petition, she asks the court to preclude my client from having any contact with Amari. Oh, and that's an end run around that. She says it's proof of stalking and harassment that my client knows her children's last name, when that's another lie. Julia Cruz is not Verna Henry's child. Julia Cruz, her real name is Julia. She is the daughter of the man, the 40-year-old convicted sex offender with whom Verna Henry is now, pardon me?
Not sex offender.
Not sex offender. With a significant criminal history, felony history. She's living with Raul de la Cruz, who is the father of, yet Ms. Henry wants this court to order restraints on some having to do with someone who's not even her child and whose last name she misrepresented. I could go on, but I won't. I will finish with what I said at the very beginning. Ms. Henry has offered literally, she didn't even talk about the incident at the mall, which didn't arise to harassment, which my client for the family law trial is in the process of getting from Westfield Capitol Mall, the video. And I'm not offering that as evidence. I'm just saying, to demonstrate our state of mind, we're acting in all good faith because we are playing house. We are now together. We have a child, Tia Lewis and Brandon Carrington. And this is all barred by res judicata, Your Honor, as well as bad faith, as well as a lack of substance. Thank you.
Thank you both. Okay. I appreciate you taking some time to address my initial concerns about it, because it's important that this court doesn't sit and rehear matters that have been heard by other courts. That's important for the court system, and ultimately the reason it's important is because it's not fair for people to have to go through court proceedings that they've already been through before. That's why I brought it up. That's why I wanted to make sure that we didn't essentially do that, because it's not fair to people. But I also, in an abundance of caution, I wanted to make sure that I wasn't accidentally keeping you from being able to present things to the court that you should be able to present to the court in order to make your case for an anti-harassment order. Because it's equally important that you be able to do that. So that's why I was a little bit careful about this. And you probably weren't anticipating you were going to get dragged into legal issues like that that are more commonly addressed in law schools than they are in anti-harassment hearings, but they're important. So, Ms. Henry, the issue here is that I think that the way you are presenting what has happened in your relationship with Ms. Lewis Hoxie, you're presenting that to the court as harassment. And the problem is that the way common people understand the word harassment is a different thing than how the law defines harassment in order to cause the court to issue an order. Okay. So in real life, harassment is things like when somebody posts stuff about you on social media to drag your name through the mud or trash talk you around town or make you look bad in your community to your friends, your neighbors, you know, the people who matter to you. That is not really harassment. What you're talking about there is, you know, you may have heard terms like libel, slander, defamation. It's like that. Okay. Those are different legal causes of action, and they're not harassment, and they're not the kind of cause of action that can be brought in a district court. Okay. So I can't look at what you told me about the nasty things that she may have posted about you on social media or made accusations about how you're an aggressive person or something like that. I can't consider those as harassment because they aren't. Harassment means something different. It's a willful course of conduct directed at a specific person that seriously annoys and is detrimental and would cause a reasonable person to suffer substantial emotional distress and serves no legitimate or lawful purpose. And I have to keep in mind in evaluating that, one, constitutionally protected speech, because people are allowed to say mean, nasty things about you. That's the world we live in. And it does not prohibit people from being rude, overbearing, and obnoxious. Okay. Now, she may be all of those things, and that still wouldn't bring it within harassment. Okay. So in this case, based on what I see here, even before I start taking out the things that have already been adjudicated by other courts, it doesn't constitute harassment. I think I understand why the other courts didn't issue you an anti-harassment order or issue her an anti-harassment order, because this material isn't the kind of thing that constitutes harassment. Okay? It's unpleasant, sure. It may cause you to have a different cause of action for damages, maybe. I don't know. But it doesn't entitle you to an anti-harassment order.
Even when they show up to my home and I have witnesses of that?
Like I said,
taking and threatening my stepdaughter.
Like I said, these things that have happened that you have provided evidence of are not harassment. Taking into account the things that are not considered because they've been subject to previous litigation, it's even a weaker case of harassment. So for those reasons, I'm going to deny your petition. And I do believe there was a temporary order. Yes, there was a temporary order issued in this case. That order is terminated as of this moment.
So if anything happens, just call the cops and hope they get there in time.
Well, I do want you to keep in mind what I said earlier about if your safety is at risk, it's always okay to call the police, even if, you know, if you think I got it wrong and I made a bad decision here and didn't issue you an order, that is completely irrelevant if your safety is at stake. All right. There's 911 and you use that. Now, if other things happen, if there's a course of conduct that develops, you are free to bring another petition for an anti-harassment order. You can present to the court anything that occurs that you think entitles you to an anti-harassment order. I'm not telling you you're not allowed to come to court. The clerk is making copies of my order to give to you, and then that'll conclude the hearing.
Thank you, Your Honor.
Thank you.
Always a pleasure.
Am I saying your name right now?
Anise, like a nephew.
Anise Coultier or Coultier?
DA.
Cloutier. All right. I will try my best to get that right. Thank you. Okay. Now this case, if I recall from the docket notes when I could see them, it was heard last week, or it was called last week and not heard and reset to today.
That's correct.
That's correct.
Okay. All right. We ready to proceed today?
We are.
Yes.
Okay. Very well. I've seen the exhibits that have been submitted by both sides, the initial petition and the declarations. So beyond the record that's been established by filing of declarations, is there any need or desire for additional evidence in the form of testimony by either side?
Your Honor, I would just like to clarify, since I filed it on Friday afternoon, and I believe that this technical glitch started on the weekend, I just wanted to make sure that Your Honor had the opportunity to review Anise.
I have a Hagan declaration, a Hazelton declaration, and a McMahon declaration. Those are Mr. Coker's filings, and the petitioners are declaration of Quintanilla, police report, and then subpoenas for Hagan and McMahon.
So it sounds as though the court may not have Ms. Cloutier's declaration or Mitch McMahon's supplemental.
You filed those on Friday?
No, I filed Ms. Cloutier's on Friday and Mr. McMahon's supplemental, I believe, on Wednesday of last week.
Supplemental declaration of McMahon was filed on the 31st, on Thursday.
Yes, and Ms. Cloutier's was filed on Friday, the 1st.
That would be beyond the filing deadline anyway. And it doesn't appear that it's been added to the file yet. Make sure it's not just filed in the wrong place. Okay, gotcha. Okay. All right, well, does that affect how you want to proceed?
Yes, Your Honor, if the court doesn't have access to Ms. Cloutier's testimony in the form of her declaration, then either I will need to take live testimony from her today or request a continuance.
She did submit a petition.
Yes, the declaration that she submitted was much more detailed.
All right, I'm a little concerned because I was given to understand that there was some urgency in the continuance of this matter from last week to this week. And the filing deadline for protection order cases is Thursday prior to the hearing date, which is not an onerous deadline considering that's only 2 business days. And you told me you didn't file it until Friday, but it's absolutely critical that I have it.
Well, the information contained in it, I believe, is critical for the court to hear, whether that takes place versus, in the course of live testimony or otherwise.
All right, well, I guess there's no reason we can't proceed since she's present and she can testify, but Mr. Coker, do you have any opinion on that?
Your Honor, I just, again, this was continued 1 week. I would also note the court at that time rescinded the temporary no contact order. The declaration from Ms. Cloutier that was supplemental that was filed Friday basically kind of adds 2 things, which I think she feels is necessary to do to try to survive dismissal of this action. If she wants to testify, I guess that's fine.
Go ahead with the testimony.
That'd be our preference.
All right, well, if there's no objection to that, we'll just take it in the form of testimony. All right, so Ms. Cloutier is the petitioner. She gets to go first, so.
Thank you. And just as a matter of note, I would like to point out to the court that when the temporary was dismissed, the court had no information whatsoever from petitioner's side. Ms. Cloutier, can you please tell the judge?
Well, before she testifies, let me swear her in.
Apologies.
Okay? All right, Ms. Cloutier, would you raise your right hand, please? And do you swear that the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, go ahead.
Can you please tell the judge what prompted you to seek a restraining order against Mr. Hazelton?
Initially, when I had spoke to my assistant manager on the October 2nd event, I was told that the matter would be handled with upper management. Days had gone by and nothing had been done. So was speaking with some of my friends and that were also in law enforcement, they urged me to protect myself and make sure I had it documented with the police.
Let me ask a more specific question. What event involving Mr. Hazelton prompted you to seek a restraining order?
Well, on October 2nd, between the hours of 12 and 2 p.m., I was at work. I was alone in the warehouse, about to descend some stairs to the sales floor, and I could feel and hear somebody coming up behind me. I right away took a step to the side to let this person pass, and in passing, I saw that it was Christopher Hazelton. As he was passing me, I decided not to follow him because in doing so, I heard him say very angrily and with gritted teeth, "I wish I could fucking shank you." So I did not follow him down the stairs. I looked at him when he said that. I was split to the side and observed him very angrily saying that towards me and walking downstairs. I looked around, nobody was there. As far as I know, we were the only two people there and that nobody heard.
Have you had the opportunity to review the declarations filed in this case by Mr. Hagan and Mitch McMahon?
Yes.
Can you tell the court whether you, what your opinion is about those declarations and whether they're describing the event that you filed a restraining order for?
As far as Mr. Hagan's declaration, he is referring to a completely different situation. It was not the one that prompted me to seek the order. And as far as Mitch Mahone, his first declaration was very sparse. I don't believe he even mentioned me coming to him about the said incident. The revised, I'm not sure I'm saying that correctly, the second declaration, he did go into more detail about me coming to him with my concerns.
Are there any prior instances of interactions with Mr. Hazelton that had caused you concern before this October event you're referring to?
Yes.
What was that?
On August 8th, it was me and my assistant manager and Mr. Hazelton. We were by a computer and we were talking about a drawdown that was done, and Mr. Hazelton came over and dropped the papers in front of us and told us that we were both didn't know what we were doing and that these were wrong, and yelling and screaming, and it got very hostile. I had to step in between the two to try to diffuse the situation. There continued to be more yelling on Mr. Hazelton's side. In between the two of them, I had put my hands up to sort of distance themselves. I wasn't touching anybody, and in that moment, Mr. Hazelton smacked my hand away.
And did you talk to anyone in management about your concern regarding that incident in August?
Yes.
That's all I have, Your Honor.
Questions, Mr. Coker?
No questions.
All right, any other testimony you want to bring, or is it just Ms. Cloutier's?
Just Ms. Cloutier, but I have one last question, if I may, Your Honor.
Go ahead.
What is the thing you would most like the court to know or understand about this situation?
That this situation did occur, and that I became very fearful after it being, I already had been trying to distance myself from Mr. Hazelton, but this was just beyond anything that I have experienced.
All right, thank you. All right, and Mr. Coker, were you going to put on any testimony beyond what was presented in the form of declarations?
Nothing additional. We'll stand by my client's declaration.
Okay. All right. All right. In that case, then, I'll have each side essentially sum it up. So starting with you, Ms. Overbilly.
Thank you. The court now has 6 declarations, or excuse me, 4 declarations before it, as well as a copy of the police report, wherein Mr. Apologies, that was in Ms. Cloutier's declaration. Mr. Hagan spoke to police in this matter, and he filed a sworn declaration. The sanitized version that came through in his declaration says he didn't hear. He was present for the interaction. He thought it was a joke, thought it was dark humor by Mr. Hazelton, and that he didn't think that it was a big deal, but he did hear the word shank. In his declaration to this court, which was sanitized, he said just the opposite. He didn't hear anything said, and he's aware of no complaints against Chris Hazelton. So there's a lot of inconsistency about things that matter. There are inconsistencies between Mr. Hazelton's statement and Mr. Hagan's statement, as well as Mr. Hagan's statement and the police report. What's the truth? Anise has consistently reported the same events from the beginning, from her reporting the August incident to Mitch McMahon, to reporting the October incident to Mitch McMahon, talking to Mr. Hagan about it, telling a coworker, Mr. Quintanilla, about it. She finally reported it to the police due to lack of company response, and then submitted, strike that. That's the declaration that the court has not seen. So her story from the very beginning has been consistent. To address the alarm component, Mr. Quintanilla testified that she seemed legitimately afraid and that he was trying to calm her down. Mitch McMahon, for his part, testified that the shank threat was clearly weighing on her. And notably, Mr. McMahon did testify to, during the August 8th incident, he wouldn't even let Mr. Hazelton get in a position that was behind him due to how upset Mr. Hazelton was in the workplace. Would a reasonable person feel threatened by a statement that they wish they could shank you? I think the answer is yes. A reasonable person would also feel threatened. Thank you, Your Honor.
Mr. Coger.
And Your Honor, obviously the court's seen the information here, the declarations. And so what I think is relevant here is this. It's very clear Ms. Cloutier is not getting the feedback response that she's looking for. And that's really, really evident through the material. So some incident allegedly occurs in early October. It's disputed what happened. She tells the police, she says nothing about the F word, the gritting teeth, all of those things, which jump forward to today is what we get. But back when she went to the police handled it appropriately and didn't do anything. They did, however, as did her friends that are in law enforcement, say, hey, go get a no contact order. That's the ticket. So then she's like, okay, I got to go get a no contact order because I'm not getting the feedback from my employer. And mind you, Your Honor, there's no like long-term relationship with these folks. They work minimally together. It's clear Ms. Cloutier doesn't like this gentleman who's worked at this company for 23 years. She's been there a year and 7 months. So in any event, she doesn't get the feedback she wants from the employer because, quite frankly, the circumstances she's saying occurred did not occur, which is evident from the declaration that are submitted from the 2 witnesses. So now she's faced with the problem of she doesn't get the feedback from the declaration. So what does she do? She goes and she files a declaration herself with this petition. And it says nothing about, again, the F word and the gritting teeth and all of these types of things. But then, as was expected, this was continued a week. And then we get this new testimony. Because again, Ms. Cloutier is very worried about not getting feedback from this court. So Obviously, on behalf of Mr. Hazelton, my position is this court should not give her feedback because, as the last court did, there was not even enough at the time. And contrary to what Ms. Overbillig stated, was the court did have information. They had our declarations that are still before the court today. And the judge at that time, Judge Meyer, struck the temporary order. So again, Ms. Overbillig hit the point. Would a reasonable person have felt threatened in these circumstances? Nobody else did. And there's a big dispute as to what actually happened. The fact is nothing happened. And the fact is Ms. Cloutier, for reasons that remain unknown at this point, is pushing this issue at every possible level she can. And this is an example of what I believe is what's unfortunately becoming some of the issues with these no contact orders. These are serious matters. The law is very serious. They define what unlawful harassment is. They define recurring incidences. They define what a threat is. She meets none of those criteria, but yet she's pushed into this system, into this process over and over again. And we're seeing it at the schools. Schools are refusing to take care of things. So now they're sending people, well, we need to, if you get a no contact order, bring it in, we'll deal with it. So in conclusion, I just don't think the evidence is sufficient. I think there's credibility issues on the part of Ms. Cloutier because of the differences in her testimony today and her declaration, her delay in doing anything. And really, we're here because she didn't get the positive feedback that she expected from her employer. She didn't get the positive feedback she expected from the police. And now she's doing everything she can to get some level of positive feedback. And I just, again, I think the out for this court is just simply she doesn't meet the legal criteria for a no contact order. So I'd ask the court to deny the petition. Thank you.
The last word, Ms. Overbillig.
Thank you, Your Honor. Mr. Coker has indicated that the temporary order was dropped, which is accurate. At that time, nothing before the court from Ms. Cloutier's witnesses. And Mr. Coker has chosen not to ask Ms. Cloutier why she didn't include the word effing with the police. She's been consistent about the threat since the day that it happened. Mr. Coker indicated that no one else seemed to feel threatened, but there was no one else there. In this instance that my client has testified about, it was only the two of them there. And she has legitimate reason to be concerned about a threat to be shanked. Thank you.
Okay, well, there are policy issues that Mr. Coker has raised that I've heard that in context of these orders before, and I understand some of the frustrations about various entities, including employers, neglecting their actual duties in favor of having the courts make decisions like this, schools as well. I'm not going to say he's wrong about that, but it's not a basis for me to make a decision one way or the other in this case. I have to apply the law. In all these cases, the standard is the same. The unlawful harassment would be a knowing and willful course of conduct that's directed at a specific person, which annoys, harasses, is detrimental, and would cause a reasonable person to suffer substantial emotional distress, and which actually causes that kind of distress and serves no legitimate or lawful purpose. That's the standard I apply. And there's a preponderance of the evidence standard. In other words, the acts have to be proved by a preponderance of the evidence, greater likelihood that they occurred than that they didn't. And there are a couple of caveats to these, of course. We can't restrict First Amendment activity. And we have to keep in mind that this statute that allows for these orders is not designed to penalize people who are overbearing, obnoxious, and rude. So with all of that in mind, applying those standards, I'm not satisfied that unlawful harassment has occurred here. I'm not persuaded by a preponderance of the evidence that the acts alleged occurred as alleged. And even if they did, that even if I believe that they have been proved in context in which they have been presented, I don't believe that a reasonable person would suffer serious emotional distress under these circumstances. I do agree to the extent that I mentioned before that this is a workplace issue. There may be rules, regulations, policies in a workplace that have been violated, and there may be remedies there, but this is court. The situation is different. We're not here to resolve workplace disputes or organize workplaces in ways that are conducive to, a pleasant place to work. That's the responsibility of owners and managers of businesses. And there's nothing about my decision here that prohibits you from taking up your complaints there and maybe even getting some vindication there. The rules are different, is what I'm saying. But here, I don't believe that the burden has been carried for the reasons that I explained. So the petition for the anti-harassment order will be denied.
Thank you, Your Honor.
Okay, make sure I get everybody's name right. Tahiri, Tahiri. Okay, and you are?
Jack Brown.
Jack Brown, okay, that's both petitioners. And you're Jesse Davies.
I am Jesse Davies.
Okay, and are you here with him as a support person?
No, he's asking me. My name is Diane Brown, and in all the evidence, especially the newest printed evidence that was submitted to this court, 1028, filed with this court 1028. I didn't have an opportunity to get that until I think late last week, and the videos, which I couldn't view until I got a computer technical person to assist me. They made it real clear that this isn't just between the petitioners and the respondent, but my name and property and house address are listed throughout, even in the police reports prior to that.
Okay, let me kind of slow you down right there. Who are you in relation to the case? I see you're
I'm
not
the property owner.
The property owner.
The property owner of 39
Okay.
And have knowledge of much of their evidence.
So are you a witness
So
then?
yes, I would say I'm
One of Mr. Davies's witnesses, is that it?
or I would have knowledge on many of their the police reports. I'd have knowledge of the printed part.
Well, let me get started here on the case, and we'll
Sure.
see how this
Yeah.
develops. All right.
Thank you.
So, Mr. Brown, Mr. Tahiri, you brought this petition for an anti-harassment order against Mr. Davies, and Mr. Davies is here in response. Mr. Davies, are you ready to proceed?
Yes, Your Honor. I
Okay.
feel like I am. I feel like I'm
Okay.
fully prepared to defend my.
That's all I need to know. All right.
Understood.
So, and
Understood.
I take it that the petitioners are ready to proceed as well. All right. So this is what we'll do. I'm going to swear you each party in, and then I'll decide the case. Now, keep in mind that generally speaking, cases like this are heard based on evidence that's filed in the form of declarations, which has been done here. It may or may not be necessary to take any additional evidence in the form of testimony. That just kind of depends. We'll see. But I'll give each side an opportunity to present their case. And so that's the petitioners first. So they'll present their case. I'll listen to that. I'm going to ask that they not be interrupted in that. And then after they've had the opportunity to present their case, then it'll be the respondent's turn. That's you, Mr. Davies. Same thing. You'll present your defense to this petition. And same thing, no interruptions with that. Except that I may need to ask questions. If I need to ask questions, those would be the interruptions. Okay. And I will only do that if I really need to be sure that I understand what you're telling me, or if I need to help sort of direct you on to facts and circumstances that'll help me resolve the case. Okay. And then after I've heard from both sides, I'll make a decision as to whether or not an order is going to be issued. And I'll explain to you kind of the reasons why. If you saw the last hearing, you saw a little bit of that. All right. So with that in mind, the parties, please raise your right hands. Do each of you swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth? Okay. All right. So Ms. Tahiri and Mr. Brown, you get to go first.
Good morning, Your Honor. Thank you for hearing us today. I'd like to start off by saying that Diane Brown is correct that she is not the respondent, but she is incorrect that this case is about her or any issue that may have arisen with her and I and my wife being neighbors. This case is strictly about Jesse Davies and his knowing and willful course of conduct that has alarmed, annoyed, and harassed both my wife and I, serving no legitimate or lawful purpose. Mr. Davies has violated the Washington Administrative Code 173-60 multiple times for Class A EDNA, which is what both of our properties fall under. They're both residential properties. I've submitted noise measurement reports and decibels. It's a free application called NIOSH Slim. NIOSH comes from the National Institute of Occupational Health and Safety. It was something I learned about during HAZWOPER training and refresher courses over the years. This noise has exceeded all OSHA requirements in both quantity and time of duration. OSHA states that at these noise levels, one should be wearing hearing protection, and their exposure to this noise should be limited to less than 8 hours a day. Sometimes the noise that is starting this has gone on for up to 10 hours a day. Prior to notification of both parties' awareness of this, Mr. Davies has peered through the windows of our home, starting at my office window, which does share the property line, my wife's office, which is at the back of the house, and he needed to actually reach the rear corner of both of our properties to do so and lean underneath the foliage to get a good look through us. He has leaned down trying to see underneath of the blinds at the front of our house to peer in when the blinds are cracked open for our dog to look out. And it's honestly gotten to the point that we are quite alarmed. We were unaware of a lot of this and his potential for harm until Mr. Davies had told me a story of him hurting a girlfriend who left his house that morning to go live down in the jungle encampment. He had explained to me that he had gone down there looking for her and that some men had been angered about him searching for this woman. And he was worried that these men would come to his mother's property trying to find him. And he was worried for her safety, asking me to look out for her. I agreed. We had always had a cordial relationship with Ms. Brown, and there was no issue between us at this point. Mr. Davies has crossed our property line numerous times without invitation to come talk to my wife or I when we are in front of our garage. It was our own naivety that did not tell him to leave because we were, again, cordial with our neighbor and her son. Starting on September 11th, around 12:30 in the morning, Mr. Davies was sanding a RV trailer that he's been attempting to remodel in the driveway of Ms. Brown's property. This was prior to all of this noise going on, and it was kind of my final breaking point that he was outside of the standard hours of noise for a neighborhood, being after 8 p.m. At 9:37 in the morning, I texted his mom saying, hey, he was out there doing this in the middle of the night. That is substantiated in the text documentation between myself and Diane Brown on pages 9 and 10. Mr. Davies was relatively quiet that morning, and I have reason to believe that it was after that text message went out, his mother had contacted him and told him to keep it down, as she was not home at the time. The first time that Mr. Davies began pressure washing was as soon as I had somebody come over to the house to look at my boat, which is on the side of the house which our properties share. Person interested in the boat came over at 6:51 p.m. and left just before 8. The pressure washer turned on the moment we were out there, and turned off the moment this man left. This was the first day that he was not pressure washing for the better part of the entirety of the day. The pressure washer was placed within 10 feet of myself and the person interested in the boat, and within 5 feet of my property line. On September 12th, Mr. Davies pressure washed nearly all day. At 5:06 p.m., I took a decibel recording showing a 79.8 decibel reading, peaking at nearly 95 decibels. Again, this is exceeding OSHA limits for even with hearing protection for over 8 hours. At approximately 5:10, I walked over to ask Mr. Davies to please move the pressure washer onto the other side of the RV trailer he was working on, in hopes that it would at least stop some of the sound from ricocheting between both of our homes, because that was the majority of the issue with where the pressure washer was placed. I understood that he was working on a project and I wasn't trying to interrupt him doing what he was doing. However, I explained to him that it being right outside my office window was causing me severe anxiety, headaches, and I honestly couldn't focus on my work. I do work from home. At 5:25, I ended up making a noise complaint. I had asked Mr. Davies before I did this one more time to please move it onto the other side of the pressure washer, or I would be making a noise complaint. I did this within view of him. And at 5:32 p.m., Olympia PD officer R. Donald had arrived. Mr. Davies had stopped, cleaned up shop, and was nowhere in sight. I believe this is because I did say I was making a noise complaint and he did not want to be doing this action when PD had arrived. On September 18th, Mr. Davies witnessed my wife and I out on our property. I truthfully don't remember what we were doing, whether we were gardening or walking the dog, but he immediately began pressure washing as we had walked out onto the property. This was the day I made my second noise complaint. This was 6 days after I personally notified him that these actions were annoying and were harming us, and 7 days after I had notified the property owner of these actions as well. I forgot to mention that in that notification to the property owner, I did state would be happy to share the Washington Administrative Code that he was in violation of. I did say that if this continued, I would be making a noise complaint and that her address would be listed as the property, as this is where these occurrences are happening, but that Jesse Davies would be the one named in whatever action to be taken. On September 19th at 11:26 a.m., I made yet another noise complaint. I have a 1:43 p.m. reading showing 65.1 decibels, peaking at 85 decibels, again, over the the OSHA limits of what is acceptable for working conditions. At 3:24 p.m., Olympia PD Officer Jay Watkins arrived to Ms. Brown's property to discuss our complaints with her. Speaking with him on the phone, he had asked if we would like him to go speak with her, and we did. The property owner states in this time that Jesse Davies does not live there, and she also does not believe that any of this is happening and that it is wrong, or that it was not wrong, I'm sorry. But again, she was made aware of this 8 days prior, and he was made aware of this also 7 days prior. On September 24th, I took yet another reading, 75.1 decibels, peaking at 99.7 decibels, and made a noise complaint in the following minute. I believe it ended up turning off, and I called back stating that this wasn't happening anymore and that nobody needed to arrive. On October 10th, Mr. Davies heard my wife and I outside as we were preparing for a dog walk. As he was riding his bicycle out of his mother's driveway, he diverted his bike from the center line of the roadway onto our side of the street, came within approximately 5 feet of us, slowly passing us while turning both of his shoulders to our direction, menacingly staring and moving closer aggressively to us.
Mr. Brown, you don't have to repeat everything that you've already submitted in declaration form. That's kind of the reason it's submitted in declaration form, is I've seen this and read this, and so it's not, you don't have to say it again. But if there are are specific things. If you want to argue for your case for an anti-harassment order, you can point to specific, instances that are supported by the declarations that you
Okay.
filed. That's fine.
I guess I'm just trying to really hit home the point that both parties to my right have been notified for this actions for over a month on end. And that originally we did try to solve this between neighbors.
Okay. Mr. Davies, let me hear from you.
Oh, thank you, Your
And
Honor.
just to remind you too, I have the material that was submitted and on your behalf too.
Your Honor, is that what was filed on November 1st, the
Yes.
handwritten document?
Mhm.
Thank you.
Yeah, go ahead, Mr. Davies.
Your Honor, I feel a great relief that the court is now handling this matter, and I am thankful for that. I realize that this is probably my one and only chance to tell my side of the story. I will do my best to not to waste the court's time. My mother, Diane Brown, owner of the three, is here in the courtroom today and wishes to be heard by the court. What she has to say definitely pertains to this case only. She is fully prepared to answer any questions that the judge might have about this case, as this matter greatly affects her. Your Honor, the petitioners of this restraining order that has been placed against me bought the house next door to my mother's house not too long ago. I visit my widowed elderly mother quite often. My mother needs my help with a variety of things, so I come and go, and I am there quite often, helping my mother with a variety of things that she is unable to do. My mother and I have been experiencing a constant bombardment of a very wide variety of complaints from the petitioners of this restraining order. It has been very stressful and mentally exhausting for both my mother and I. I have often wondered, why are they doing this to us? No laws have been broken. A lot of complaints are about me making noise at times when I am not even there. Or they claim that I am running power equipment after the noise ordinance shut off time. And now, for a long time, they just call the police on me anytime there's any noise they don't care for in the neighborhood. Quite often, for long periods of time, the lady petitioner rarely misses a day of screaming insults at me at the top of her lungs from her property. So I just hear these unfounded accusations and insults. Your Honor, I have never responded to any of these screams at the top of her lung accusations from the lady petitioner. Not even once, Your Honor. I have no wish to participate in any bickering with my mother's neighbors. Harassment is a form of violence, and I know that. I did not even know her name before this restraining order was placed on me. Your Honor, I am sure that you are aware of the fact that I do have a domestic violence on my record. And while I am not proud of that, I went to all of my domestic violence classes that I was ordered to by the court. I paid attention in class, and I had a really good teacher. My teacher even allowed me to go to his classes after I graduated, and I took advantage of that. So, Your Honor, I hope you can see that I have no wish to bicker with, harass, or any other form of violence towards petitioners. I understand that petitioners are saying that they fear I will harm them. I can assure you, Your Honor, violence is not and will not be an option for me. I have not and will not ever allow myself to even entertain the idea of that. Although I have left my mother's property and distanced myself as a result of her screaming insults at me, the petitioner of this restraining order constantly tell my mother that the petitioners, excuse me, Your Honor, of this restraining order constantly tell my mother that none of this is against her, while my mother is the one that has been negatively affected the most. My mother is not one to complain, but she is worried she will have to sell her house to get away from the petitioners and the stress of having to deal with their constant bombardment of unfounded complaints. Your Honor, I know that it's okay to experience anger, and it's just what we do with it that matters. I know why the laws are the way they are, and I know that they save lives. I am not upset with this court or the petitioners for placing this temporary restraining order on me. About the video evidence with me and the leaf blower, I was scared. I turned around only to see if she was chasing me, so I would know if I had to run or not. To get away, I was shaking because I was scared. I read the blower on accident I am grateful to offer through the court my apology to all involved and through the court to seek a peaceful resolution only. And Your Honor, that's what I have. That's my statement that I prepared. I really feel like any of these accusations against me, that I feel like I did prepare a defense for them but I don't feel I need one. They're just accusations. I'm not guilty of them. And so I'm prepared to respond to any questions that you might have, Your Honor. And please allow my brother to talk, as this case greatly affects her. And so I think that's all I have, but I would like to answer any questions that you might have.
I think I just really only have a couple. Just so that I'm clear, you don't live there with your mother?
It's not my residence, no.
Okay, you live someplace else.
Oh, excuse me?
You live someplace else, but you come over a lot to help your mother?
Yes, that's sir. That's correct.
Yeah. All right. I think that's just what I want to make sure I understood clearly.
Well, if I may, I'm pretty scared that I won't be able to help her anymore, and I'm scared that this is affecting her health. And so I'm not. That's all I have. That's all I have. Yes.
But you want me to hear from your mother?
What's that, sir?
You want me to hear from your mother too?
Oh yes, if you wouldn't mind, I would appreciate the court to patience and time and thoughtfulness.
And
yes, please.
Ms.
Thank you.
Brown, why don't you raise your right hand, please? And do you swear the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. So, Mr. Davies, what would you like to add? Would you like to ask your mother questions?
I'm not good at this. I feel that no matter what happens with this outcome, I just feel she deserves a chance to speak. So, because it greatly affects her. I don't know that this will help my case. If you don't mind, then it definitely pertains to this case.
Can I ask you a couple of questions then?
I hope you ask me a lot of questions.
Well, I'm just going to have a couple. I want to make sure that, you know, this is sort of fairly heard. And
right.
So, you know, the petitioners have brought a number of allegations about specific things that your son has done related to noise, related to trespassing, related to peeping. Now, do you have any personal knowledge from your own experience, in other words, seeing or hearing yourself, not hearing about it from your son, but just observations yourself that you can tell me about these allegations that Ms. Tahiri and Mr. Brown have brought?
Okay, I did get this printed evidence they submitted just recently, and I couldn't respond to everything that I saw that was like partial truth, taken out of context, untruth, things like that. I couldn't respond to all of that, all of the police reports and other things that were submitted in writing. And I'm telling you the reason why. I'm going to try not to waste your time too. In a one cohesive written, document and submit it to you in time, because I'm 70 years old and like many seniors, declining. I'm slower in thinking, concentrating, acting on deadlines, organizing thoughts and written documents, reading and spelling. I can't do many things that I used to do. I can't climb on my roof. My balance is bad. I can't do heavy lifting, sun exposure. I have torn meniscus in both knees, curvature of the spine, and I can't do many things that I could do 40 years ago when I was about the petitioner's age. I can't do them. I don't have technical equipment and I don't know how to use it. I even purchased a laptop on Monday and had it hooked up by professionals on Tuesday, but I didn't even know how to use it. And so I would be trying to write responses in time and then I'd rip them up, and then I would be in bed with severe headaches and diarrhea. And I don't wear Depends, but I wear them now. My husband had a stroke in 2009, and his care was expensive, even though I did very much of it. had him with me for years. He was in an adult family home for 5 years. That depleted our resources. So it's not like I can hire people to do things for me, to like do repair projects or maintenance and things like that. And I operate with hand tools because I don't have to keep them running. So unlike other widows in my loop, I can't hire too much done. So Jesse comes over and does big projects. I mean, they make it out to sound in their documentation that he's on the roof peering in their windows. And I mean, he worked on the back porch. I have pictures of it, of what it looks like. And it requires a lot of high up work on ladders and things like that. And I don't think I could even peer in their windows. The thing is, we have I'm trying to make this short, but I know I'm skipping a lot of stuff. We have a very narrow boundaries between their west side and my east side, very narrow. Most houses in our development, the houses are placed more in the middle. But with ours, it's very narrow between our boundaries. And they happened to buy a house that had very narrow boundaries. And some of the issues with foliage and stuff or peering in, I mean, they removed several trees and a lilac bush, a big one, and a lot of stickery foliage from their back side that boards the green belt. And so that made the whole, I think it's south side of their property, very visible to people that, like, sometimes a lost person or a homeless person comes and cuts through their yard or cuts through my yard. Well, if it happens to their yard, they really come unglued and are really paranoid. I just tell the person, if you want to get to Balsam, go that way. Okay, finish going through my yard because they're in the middle of it, or go back to the Greenbelt and go out to Slater Kenny. I was really happy that you're giving me an opportunity to talk, because I even wrote something up about that will educate you more. At least you can take about our neighborhood and the traffic.
Yeah.
So Balsam, the street we're on, Balsam Avenue Northeast, goes from Slater Kenny back to the Chehalis Trail. You go up that block and you have access to the Chehalis Trail, back and forth. And so we've got local schools, people, we've got regular bikers that some of them look like, professional, bike riders, and some of them look more like they're homeless and stuff, and people going to work via bikes and cars and walking. And so that's kind of like the traffic around and the noise around. Now that I'm talking about noise, I question why they didn't go to code enforcement, because at first I didn't know that some of this stuff was police reports, and I didn't know that I could ask for copies of them. Once I asked for copies, I mean, if I have a file that contains the police reports, and if you allow me, I could go right through and say there's a lot of things that I thought, if the judge did have time to look it all over good before, would be amazed at the wording. I mean, one of the police reports, it doesn't even have the petitioner's name on it, one of the police reports, on who made the complaint. And there's one that you can't even tell if it's against Davies or the homeowner or both, because the police report might say they and them. And so who is they and them? They're just poorly written and misleading. And if I had them in front of me, you allowed me the time, of course, I could tell you that. Same with, if I was allowed the time, I could go through all things in here that are clearly untrue. I mean, my side of the story is, and if you cared to read what I wrote about the noise in the whole neighborhood, and other people doing remodels and adding porches, and and cutting bricks, very noisy, dirty things that can get a neighbor's car dirty, or just a lot of this noise complaint. And I just questioned why they didn't go to noise enforcement. Once I realized that the complaints were all police department reports, I went downtown and I just, because it was just next to the police department where I got a copies, and talked to someone that I used to know from St. Martin's College, because he's a business owner. And I explained about all the noise complaints, and he said, well, you need to go to noise enforcement. So I went up to noise enforcement on the 24th of September, and I talked to Jeff Finch and Dylan. I've got their cards in my wallet, and I submitted them, even though my table of contents and things were late. I did submit them, and it was, I knew it was really late, but I'd been in bed most of the week and didn't have the equipment to reply with. So I did the best I could as soon as I could. Like I say, I don't have the ability to do like a college thesis, all, like in the right format and everything. So anyways, I went to noise enforcement on the September 24th. And when I explained how one of the policemen treated me, they said our officers would never do that, because I wasn't allowed to speak. I asked for a copy of the ordinance and they wouldn't give it to me. And I really, in my mind, questioned, and I'm not a paranoid person, but I questioned if it was really even a police officer or someone that was.
Ms. Brown, Ms. Brown, I'm gonna kind of pause you right there, because I know this is important to you, but the things that you're telling me are not particularly relevant to the issues before me in terms of resolving the petition. So
I have one more.
I'm gonna kind of, I know you want to say things, but I'm just sort of put that aside in your mind for a minute, because I want you to be, if you can be, this isn't a requirement, but I want you to, if you know, tell me what happened with regard to these incidents that have been raised by the petitioners, right?
Okay, what happened about these incidents?
Yeah, if you know, if you were there, if you saw it or heard it yourself. There's been allegations raised about what Mr. Davies did. And if you know anything about that, can you respond to that? If you don't know anything about it, that's fine too.
I do know about some of them. I do know about some of them. I saw the video. I saw a video that was put on my email, and with a professional computer person helping me bring it up. I saw the one about the leaf blower. And I don't know if you saw it, but to me, I thought it looked pretty incriminating against the one of the petitioners. Streets. Yeah.
Do you know anything about that circumstance other than you saw the video later?
On the leaf blower? Okay, I do know something. I noticed, I think on that day, that the leaf blower looked like it might have started up by my handicap ramp, because all the needles were blown off there, and on my driveway some, and I didn't have a view of what happened in what one of the petitioners started filming. I didn't have a view of that. That's all I can say on that. But I did see what I saw in the video.
May we have a chance to respond?
Yeah. Your Honor, I feel like this is my turn, and this is probably my one and only chance. I excuse me. Pardon me, Your Honor. I have copies of all these false accusations against me. Now, I also, at the same time, I feel like if I start to respond to them, then that's just like it turns it into a bickering thing between them and I. So I really, Your Honor, I'm scared that if I do that, that it'll be considered bickering. But I do have definitely. I hoped you would ask me questions about any of them, because I do have a logical explanation for all of them, and I don't. So I guess I'm going to leave it at that, because unless, I hope you ask me questions, but I don't think it's your job to. But I don't think, but I also, I'm real scared that if I start to try to defend myself on these, that it will be like I'm doing exactly what I'm not supposed to do. And I know what I'm not supposed to do, and I'm not a danger to anybody. So, and I know how to handle myself because I had a really good teacher in domestic violence. I've been doing that. I've been using the tools that he gave me taught me to handle myself accordingly. And there's no danger to anyone from me as far as violence. That's not going to happen. It's not. I wouldn't.
Yeah, Mr. Davies, I get what you're telling me, that you don't want to be, characterized as a person who's dangerous or poses a risk to others.
Characterized as one thing, but it's just that the thing is I'm, no matter what anyone says or does to me, I'm not that man. I'm not going to hurt anybody.
I get that that's important to you.
Therefore,
to put out to the court so that I understand that. I get that.
Yeah.
I guess what I'm trying to, tell everybody and sort of convey here is that I've kind of got a narrower focus than that.
Yes.
So
I want to keep it narrow also.
That's why I'm, trying to get the focus more sort of directly on the allegations that have been put forward by the petitioners.
Yes, and I would like to respond to those. In fact, I need to, don't I?
Please, yeah.
Oh, okay. Yes. So, the allegations of the petitioners, from what I understand of the noise ordinance, sir, they've been saying I've been doing stuff like midnight and stuff like that, like midnight and late at night. Well, those times I haven't been there, and I haven't realized one single incident where. And I'm not trying to do this noise facetiously. I'm not, but and so I haven't realized one single time. It seems like to me like they're trying to get me in trouble for, I don't know, just to get rid of me. If this is their way of getting rid of me, well, I really need to be there to help my mother. And by the way, I do the pressure washer's no longer there. I'm trying to resolve this like peacefully without any confrontation with them. I like them, and I don't want to be. I don't need. I'm saying this to the court, please, not one only. I don't wish to have any kind of. I don't wish to harm them, and now I realize that, Your Honor, that one of the petitioners is pregnant, and so this is my one only chance. So I would wish to congratulate them through the court. I don't want to harm them. I don't admit guilt because I didn't know that I was. I don't admit guilt because I didn't feel I was guilty. So anyways, I guess that's all I have to. I really don't know how to defend myself on this. On each and every one of these, because as far as I know, they're accusations. I'm not. All these things with me peering in windows and that kind of thing. It's natural for someone to look around them while they're walking or riding their bicycle. And I'm definitely not trying to look in their windows. I don't want to. And I'm not. I'm at my mother's house a lot, and it may appear that way, but that's not what it is. I'm not that man. I'm not at all. So
I understand what you're saying. I do. But
thank you.
It's not difficult to make a ruling in this case. I mean, I want you all to understand that I'm not here to enforce noise standards that are promulgated by various agencies in the state or the city.
This is
this isn't about.
Yeah, this is about
you're not accused of any criminal behavior. These accusations that have been brought by the petitioners. This isn't a criminal context. So it's not a question of whether you're guilty of any kind of a crime.
Yeah.
I'm
danger or not
able to regulate or police the rules of a neighborhood, like a neighborhood association.
I don't
or something
expect
like that. There's often confusion about that when we're here at anti-harassment.
I don't expect
that. So, the question is whether there's been a course of conduct directed at these petitioners that seriously harasses, alarms, annoys them, and whether whether they suffered substantial emotional distress and whether or not that was reasonable under the circumstances.
Yes, Your Honor.
And the evidence that they put forward to the court in terms of their testimony, in terms of their declarations, and what they say happened establishes that. It's clear to me that, this is using, the machinery, the noise, the times it's being used, the circumstances under which it's being used is absolutely detrimental to them. And that's before I consider the allegations about peering through the windows and things like that.
Yes.
That would give any reasonable person the belief that they're being targeted by a course of conduct that's designed to annoy or alarm them. And it's doing that. So that, I think, is established. The question is now that it is established is what to do about it. I'm not going to put an order in place that says your mom can't have you come over.
Thank you.
But there is going to be an order put in place. You got to leave these people alone, right? Because what has happened to them is seriously annoying and harmful to them, and has caused them serious emotional distress, and they're entitled not to have to live like that. Now, you, Mr. Davies, may be able to resolve this yourself just by being more mindful of that.
Yes, Your Honor.
It's not an excuse that you didn't.
I fully intend to do that.
That you didn't know that they were being alarmed by it, although it's kind of hard to believe because
I didn't catch what you just said.
I
didn't catch what you just said, Your Honor. I apologize.
So I am issuing an order that's going to require you to stay away from them and not to continue any of these acts against them.
Does that mean I can't work on my mom's house?
No.
Your Honor, can we keep a distance requirement so that he cannot be on the side of her property that does peer into my window?
I don't have the ability. Now, no cross talking in the courtroom.
Understood.
Right. No, and because the reason is that I don't have a jurisdiction. This court doesn't have jurisdiction to restrict the way he uses real property
from our property.
But he does have to stay away from you. This order will be in effect for the next year. November 4th, 2025. And I want you to be clear that this order is personal in nature. In other words, it protects the individuals of the petitioners and it doesn't regulate property use. All right. So I know your great concern is that you can go over to your mother's house and help her. You can. There's no restriction on doing that.
It's not my only great concern, Your Honor. My great concern is also following the law. And I respect this court completely.
Fine, as long as you do that.
Yeah.
Your Honor, thank you for hearing me.
You're welcome. So the order has been signed. The clerk has got it. We'll file it and it'll be available to everybody from the court's records at any time. Yeah.
Thank you, Your Honor.
And you're Mr. Sprigg, right?
Yes, sir.
Okay.
I am unaware if I'm new to this whole situation. I've never gone through this before. I had my declarations from a few of the people that I live near turned in on Friday, which I don't know if you've received them yet.
Just a second here. Let me make sure the Harmons are still with us. Is Rosalinda and Trevor Harmon still there?
Yes.
I've got you on video. Okay, thank you. All right, Mr. Sprigg was just about to raise an issue. I want to make sure you can hear him too.
No problem.
All right, yeah, go ahead, Mr. Sprigg.
So I've never gone through any of this before. I have no idea how the courts work. I was told last Thursday that I needed to have my declarations turned in before court to give you time to review them. I apparently did not do that in a timely manner because I'm unfamiliar with this, sir. Okay. So have you received the declarations?
Yeah, they were filed on Friday.
Yes. Okay. And watching how court's gone this morning, I don't know that I am actually prepared as I thought I was.
Okay,
I would request a short continuance so that I can get some more information and present my case better, basically. I do have one witness with, or a few witnesses with me, but there are more people that I would like to get their input as to the entire cause of this case.
okay, let me check in with the Harmons here on that
Okay.
request and see what their position is.
Okay.
All right. So I hope you heard Mr. Spriggs' request for a continuance. Do you have any position on that?
No, that's fine.
Okay,
The temporary order is still in place.
yes, that's what I was about to say, is the temporary order would continue in place until the next hearing.
Yeah, no problem.
Can I ask a question now?
Yeah.
So the temporary order, is that barring me from returning home? Because it is,
No, it
okay.
can't do that.
Okay, well, it was in the paperwork that was one of the things he had asked for, so I didn't know if that is.
Let me, I'm gonna pull up the temporary order and just verify here what it says about that, because it can't keep you from going home.
Okay, good.
That's one of the things that one of these orders can't do.
Okay, I have children on my uncle's caretaker, so I
So
need to
just,
be there.
so that is clear with the restraint provisions in the order, I'm looking at it right here. It says no harm to the protected parties, no contact with the protected parties, including minors who are named in the petition.
Yes,
And there's nothing here about excluding and staying away from any particular place or anything like that. So it's limited to just contact or harm regarding the petitioners and the minors listed. But
well,
there's no restriction on you going home.
to be honest with you, sir, I want to have no business with them. I would like to be able to go home. I don't really like the idea of having something placed on me, but we do need to keep our distance. We do need to both have a reason to stay away from each other. I would just ask that he is not allowed to come down to my residence.
Yeah, I don't have jurisdiction over him right now to enter such an order either.
Okay,
So if you want, I mean, this whole case could be resolved if you want to just have that order entered.
I don't
as
want
is.
something on my history that looks negatively
Yeah,
towards me.
you probably want to know what the implications of that would be.
Yes,
Before you make a final decision. So I'm perfectly fine giving you an extra amount of time to get
Okay.
prepared for the hearing. And, you know, maybe one of the things you're going to want to look into is what effect that order might have on
Yes,
you
sir.
if it were to be extended. So, and it doesn't sound like, it doesn't sound like the Harmons have any objection to that. So,
okay.
okay. And then we'll just pick another date here. And yeah, do either of you have any?
The 18th does not work for me. I will be out of state, returning the next day.
Okay, so how's the 25th look for everybody?
Works perfect for me.
That's a Monday again. Is that okay for you?
Well, yeah, there's no problem.
Okay, so we'll put you down as Monday, November 25th at 9 a.m. We'll say that you've agreed to extend the order in order to allow you to prepare for your hearing. So I signed the order extending, and that is going to be filed by the clerk, and it'll be available to both of you online anytime.
Right.
And then do make sure, though, if you're going to file some additional material, to have that in by the Thursday before.
I will, sir.
Yeah,
Like I said, I
great.
had no idea.
Appreciate it.
Thank you very
All right,
much.
We'll see you in a couple of weeks then. Okay, so can I start by asking the Harmons, are you ready to proceed with your petition?
Yes, it's just me here today. Rosie was not able to make it.
Okay, and you're ready, Mr. Spring?
Yes, sir.
Okay. All right, so the way we'll proceed is this. First of all, I'll swear the parties in, and then the petitioner will get to go first. In this case, that's you, Mr. Harmon. I'll hear your case first, so that means you can testify, you can draw my attention to any exhibits or material that have been filed in this case, or you can have anyone else who's a witness, testify as well. Once I've heard your side of it, then I'll turn to Mr. Sprigg and it'll be his turn to do the same thing. And then after I've heard from both sides, I'll make a decision as to whether or not there's going to be an anti-harassment order after today. It looks like there's already a temporary one. Now, during the time the other party is telling me about their case, I want to ask you to please just let them do it. Even if you hear them say things that you think aren't true, if you think they're leaving stuff out or saying things that aren't true, just wait, because you either will have a turn to tell me your side of it in a few minutes, or if you've already told me your side of it, I already know that. So don't feel the need to interrupt anybody. Second of all, I might interrupt you to ask questions. I may need to do that so that I am sure that I understand what you're telling me. And then I may also ask questions just to kind of keep things on track to stay on the issues that are going to help me decide the case. Okay. When you're telling me your side of the case, keep in mind that everything that has been filed from your initial petition, any exhibits, any response to the petition is already in the file, in writing. It's part of the record, and I've reviewed it. So it's not necessary for you to repeat orally things that have been filed in writing. Okay. You can, though, if you think you need to, draw my attention to certain sections of that you believe make your point. So, all right, with that, we're going to get started. Can I have both of you raise your right hands, please? Do you each swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Yes.
All right, Mr. Harmon, go ahead, sir.
So you have the declaration, you have the police report. The police recommended we do this. Basically, he threatened to kill me twice, and that's the main reason for the temporary order is you can't, take these threats lightly. So I think this is the best route. He lives at the end of the unit here. So currently in the process of gathering a lawsuit together to keep everybody from trespassing through my property. They believe they have some type of prescriptive easement, but there's nothing in writing, nothing documented to give them access to go through my property. They come through, they must be upset that we're trying to gain the property back. So they come through with no remorse, trying to cause problems and threaten to, like I said, threaten to kill me twice. So that's the main reason here.
Okay. Now I want you to do this. I want to focus on where you said threatened to kill you twice.
Yep.
Tell me, here's my question. Tell me for both instances when that occurred, and tell me what he said or did that made you believe that he threatened to kill you, and what your reaction was to that.
He said, I'm going to hang you. I'm going to kill you. You don't know who, what you're doing. That is exactly how it happened. Cops came the second time when we were there waiting for the cops after his buddies stopped and threw rocks all over my fence and ran up and down the road like crazy when we were having a birthday party out here. We followed them back at the end of the road where they went into, waiting for the cops to show up. He comes walking out and starts a fight with my 60-year-old father, pulls a knife on him, threatens to kill us. This is where we're at with it. So whatever's the best situation here, this is where we're at.
Okay. All right. Is there anything else that you think that I need to know before I hear from Mr. Sprigg and make a decision?
Either if you have any questions, let me know, but.
All right. Okay. Mr. Sprigg.
This all stems from the argument over the road that he's talking about.
Mhm.
He has been harassing everybody who drives up and down that road, all the neighbors' guests. And it has gotten to a point to where people are afraid of him. The one, I did threaten his life one time while I was on the ground being assaulted by him and his father. I went out to tell them to leave the property again because in his report, it says 3 weeks earlier, but it was more around 2 months. He followed me and a friend of mine down the driveway to my house, threatening us.
After they drove by flipping us off.
Yeah. Mr. Harmon, remember what I said about interrupting?
Yeah, fair enough.
We did not flip him off. Me and my friend were having a conversation. We may have used some vulgar language, but it wasn't directed towards him. We didn't even know he was outside. He has a fence up. We can't see through it. We had no idea he was there.
Let's narrow this down a little bit. Okay. I want to know what this road, okay, the road
Yes.
that you're talking about. What kind of road is this?
It is a road that has been there since the 1930s. It does not have the express easement that we would request to have, but there is a type of easement. It is already in courts for that.
There's already a lawsuit about it. Is that what you're telling me?
Us down at the end of the community are getting a lawyer to pursue a case to get that easement.
All right. But this isn't a road like, a road like 36th Avenue or something.
No, sir. It is
something
I guess,
else.
a private driveway
Mhm.
that he is right about the middle of it. And he wanted to close it all off to everybody so he could regain his property, because legally it is his property, but his property line goes to the fence.
Mhm.
But the road has been there since the 30s. When he bought this property, it was already an existing road being used by everybody. It is the only means in and out.
So that's how you access your property then?
Yes, it's the only access we have.
Okay. And would it be fair to say then, based on what I've heard from both of you, that this road and access and use of it is kind of the source of conflict between you?
I don't have a conflict because I don't believe he's going to win. It's not my issue. I'm not the aggressor in this case.
Mhm.
Nothing has happened at his house. He has cameras on his house, on his car, on his fence. If he had any evidence, where is it? The fight that he's talking about happened in front of his Tesla. It has cameras. If he wanted to produce that evidence to show exactly what happened, where is that? Him and his father came down and assaulted me when I told them to leave because they were harassing a friend of mine. I don't have cameras at my house. Otherwise, I would produce that evidence.
I understand what you mean. And I just wanted to clarify that point about the road that you both referred to. Okay. All right. And then I'm going to turn back to you, Mr. Harmon, and ask you kind of the same question, because I asked that question of Mr. Sprigg.
Yeah.
Describe for me this road that.
So it's not a road. It's my property that folks have been trespassing on for quite some time. The lady that owned the property before me won a lawsuit against it. My surveyor just provided me with all the documentation showing that nobody has an actual prescribed easement or any type of easement to come through my property. Not only is it my property, it's the next 4 houses up. So they're trespassing through 4 parcels that they're not supposed to. They all have private easements to go out the other side. They just don't want to develop it, even though it would just take, couple couple trees taken out and a little bit of rock on the road, and they'd have access or a way to go out.
Okay, so it does sound to me, based on your answer as well, that this issue is the source.
It's not the source. What happened is that the real reason why and I haven't harassed anybody going through there. The neighbors are actually coming down and talking to me, telling me that Mr. Sprigg is trying to give them lied declarations to submit to you guys, and that they wouldn't because they have their own conflicts with him. But that's besides the point. Him and his buddies drive through here because they're upset about the road. So they drive through like idiots. They flip me off, yelling cuss words, creating conflict. We're out here with a 9-year-old girl's birthday party with a bunch of kids running around, and they're stopping at the front driveway, kicking rocks, pilling out. Enough's enough. We follow them to find out who it is. They drive like crazy, flying around, won't stop, won't let us address who they are. They go back to the end of the road, and we call the cops. He walks up to our vehicle and pulls a knife out, saying that we harassed him. And if I had Tesla video, we would produce it. There's no cameras on the Tesla.
So let me ask you this question then. What is it that you want the court to order him to do or not do?
There should be a protection order from him to be walking up to me. I don't even want them to come through my property. So I'm working on that. They have another way out. So I'm working on the lawsuit for them not to be able to come through here. Right now, I'm told I can block it all off as well as all the other neighbors. So that's
let me just hold on there with in this case, this lawsuit that you're in front of the court for right now.
Yeah.
What is it that you want me to order Mr. Sprigg to do or not?
I want a protection order against him not to come near me because it's going to be a problem. He's he's threatening to kill me. Isn't that obvious enough? He even admitted, I better not come near him. I'm threatening to kill him. He's an belligerent drunk on the weekends. He can't even stand straight, and he's sitting there acting as if he can remember the story.
All right, that answers my question, Mr. Harmon. Thank you. Okay. All right, Mr. Sprigg, I kind of cut you off there. Did you have any other evidence you wanted to present?
Nothing other than the declarations that you've already read
I
as
have.
to how he is the one being the aggressor.
I have
Like,
read the
I've
declarations.
done nothing. He has nothing on camera with cameras all over everything he has. Teslas do have cameras. They record sides, front, back, everything.
I don't.
Nothing has happened at his house. I've done nothing.
All right, I want to clarify too that you talked about a potential lawsuit, but I don't see a record here that there is anything filed yet.
No, there is not. I have
Okay,
not.
It's something you're contemplating.
I'm thinking about, yes, I want to get a
Okay.
personal injury attorney because I'm going to have surgery on my shoulder from the assault from him and his father.
All right, I got it. I understand. Okay.
Yeah, there's definitely going to be a lawsuit for the injuries.
I've got real conflicting statements here about what's going on, about who may be the aggressor and who, may be the victim of aggression. There's active denials by both of you that you did anything to aggress against the other party or to threaten or to hurt anybody.
He admitted that he threatened to kill me.
So
he's threatened me as well.
Yeah. Okay. I've heard from you. Okay. I'm gonna make a decision here as to where we're gonna go from here.
Okay.
All right. Now I want to make sure that you both understand that this court can't issue any orders on this property, this road that you both talked about, whether it's an easement, whether it's not an easement, whether you have a right to be on it or you don't, to use it or not, who owns title, who may have a prescriptive easement or any other form of easement. Can't rule on that. It's beyond the jurisdiction of the court. So I'm not going to make a ruling on it. That's going to be up to you to resolve in the correct court, which would be in Superior Court, a quiet title action or something like that. Don't know. Maybe there's an easement there. Maybe there's not. You'll get that sorted out in the proper way. Now, as far as conflicts that are personal in nature, not over pieces of property, about threats, about weapons being brandished, police being called, physical altercations, that's the kind of stuff that can constitute harassment. And it doesn't matter if the impetus for it is this conflict over the road. It doesn't really matter what the impetus for it is. It's not proper to use physical violence and threats of violence to get your way or to get the other party to back down or to you can't solve your disputes like that. And if these things are going to come to blows or to knives being produced or anything like that, that's obviously something that we have to be concerned about. Now, I have to be able to find by a preponderance of the evidence, which means, Mr. Harmon, the burden of proof is on you to show by a preponderance of the evidence, the greater weight of the evidence, that Mr. Sprigg is engaged in harassment. And listening to you both here, I'm going to say, I don't believe that burden has been met. Mr. Sprigg, Mr. Harmon, you're both, as far as I can tell, listening to what you have to say, reading what's been submitted on your behalf, you seem about equally credible to me. And you seem to have, equal passion about the other guy being wrong. But at this point, I don't have sufficient evidence.
Did you read the police report?
Yeah, Mr. Harmon, let me explain something to you. I listened to you. I read your evidence. I listened to Mr. Sprigg and what he had to say about it. And I'm making a decision. It is not appropriate to continue to argue with me. I'm going to write this decision down on a piece of paper, and that is the final order of the court. If you're not willing to listen to any of the reasons for it, I won't issue any further reasons. I'll just write it down and you can have a copy of this when we're done. But it will do you no good to argue and yell at me after I've heard your evidence and made a decision.
I just asked if you read the police report.
I told you I read everything.
So good to sign off? Nothing else needed?
Sign off if you'd like to. Mr. Sprigg, would you like a copy of this order?
Yes, sir, I would.
Okay. And There was a temporary order issued in this case. That order is removed and no longer in effect.
Thank you, Your Honor.
Okay, Kayla, here you go. And she'll give you a copy of that. You can, as soon as you got it, you're good to go.
Thank you, sir.
And I've got 4 different case numbers here. They're 24-334, 5, 6, 7. And all of these are petitions by Jessica and Kenya against the Harts, Devin and Judith. Okay. So what I'll do here is I'll hear all these at the same time, although I will make a separate decision as to each one. Okay, but I think it makes more sense and it's probably less confusing to all of you if I just let you present your case as to both Judith and Devin and have Judith and Devin respond to your case against them all together. All right. And if that gets too confusing, let me know. All right. So I'll try and keep it straight, but I may need to ask you questions from time to time to make sure I'm not getting it confused.
Your Honor.
Okay, thank you. All right, so I'm going to let Jessica and Kenya go first, and I'm using your first names just because you share a last name and it'll be more clear for me, and I think the record if I say it that way. Okay, so go ahead.
So I'm Kenya Ramos. I was in a relationship with Devin Hart for about a year. And he would have his daughter over. He has custody with his daughter right now. Throughout the relationship, it was fine. Devin had told me he was struggling with substance abuse, and his mother knew that. And I thought I was able to work with him through that to try and help him. Throughout that year, it wasn't until maybe like months ago before I put this petition order, when I would just notice him having his daughter, he wasn't really able to function on some things as a parent. And to me, it was hard to try and help him and his daughter. I felt like I was not being supported when it came to that situation, or when I would try to voice my feelings or concerns to his family or to the people around him. It seemed like that was just getting swept under. I didn't really know his daughter's mom, so I had went out my way to kind of talk with her, especially when these concerns were being raised. And I just didn't know what to do in that situation when it came to his daughter and him and leaving that relationship. So when I would go talk with his daughter's mom through text or call, and I just felt it was right for me to tell her like the concerns I was having when it came to Devin's performance when taking care of his child. Because at that point, like, I had made that decision that I didn't want to be in a relationship with him, but I would go over to when he wanted help, especially when it came to taking care of his daughter. And I just felt like that was a lot of responsibility for me to take on. And so when I had told Jennifer Scott, his daughter's mom, about it, I didn't realize, I guess, like how big this was when I heard her, I guess, her voice of just being concerned as a mother for her child. And so that led us to calling Child Protective Services. And from there is when the harassment started, when it came both from Devin Hart and Judith Hart.
Can you tell me specifically what it is they did that you are concerned is harassing you?
He had came over the first time, I guess that same day when the call went through and we called the police. And my parents, I wasn't there, so my parents told me this, that he had came ringing the doorbell and talking in a manner they didn't really understand him too well. So that was just the first thing. The second time, my brother had came home, and I guess he was pulling in the same time, and he was just yelling at him, or cussing him out. From there, it would just escalate. Like then, him and his mom. That we have a neighbor that's next door to us because his mom lives like across from us. Devin doesn't live there, but he would just start come over to quote unquote visit his mom all of a sudden, all the time, and they would go to the neighbor's house that are right next to us. They would start parking their car in that neighbor's house just to come over and I guess look or see what we were doing, or they would just make comments. From there, what really set me off more, or why I was really more concerned, was when my mom had told me that when she was leaving the neighborhood to pick up my dad, Devin was coming. And my mom didn't recognize that it was Devin driving, but until he had gotten close and was playing on the road, like trying to hit her in the car or driving around. It happened twice. One was with my sister, and the second time my mom was by herself when it happened, where he was just driving around recklessly, like just acting like he was gonna hit them or do something. And that to me really had bothered me. From there, then it was his mom and him talking to the guest. Like we had guests over, and they were just talking about, I guess, my parents' immigration status and telling all the neighbors about my parents' immigration status and just harassing the guests, just like being racist, I guess, making racial comments. And that was my concern, I guess, because being under the influence in general, like I just don't know what he was going to do. I never thought he would go to this far to be physically violent or wanting to be physically violent. And having his mom supporting that to me is what has been bothering me. And just hearing my parents concerned about their safety, especially because they know where they work or being right across from us. I don't know what he's gonna do or how he's gonna react.
All right. Jessica, do you want to add anything to that?
Well, for me, like he was harassing me by just sending me text messages or calling me. And same thing, he was just either threatening to call ICE on my parents, and he would like send me pictures of him filing out a form, or he would threaten my partner as well. Like every time he would come over, he would just start yelling at him or just getting kind of close to him. But it's mainly just that, like he was just texting me while I was at work and wanting to get my attention. He wanted me to get my attention so I could tell my sister. And but that's pretty much it. I mean, at night sometimes too, he would call me while I would be getting home and just wanting me to tell my sister to answer his texts. And so a lot of times getting home at night, I would get scared just thinking they were there. And a lot of times in the mornings, because it's a 2-story house and I sleep on the top of the bedroom and my window's right there, a view of like the whole street. And a lot of the times they just drive by and blast their music, or I can just hear them like kind of yelling outside, walking by there. But yeah, that's mainly my concern. I'm just concerned for my safety and my parents.
Okay. All right, then Devin, can I hear from you first?
Sorry, I was trying to unmute it, Your Honor. Yeah, so the relationship recently has been about a little over a year. And recently all of this started, there was never an issue. I had gave Kenya an STD, and she's always battled with insecurity. She's really insecure, always worried about me going back to my daughter's mom, when that's never going to happen. And she honestly has totally ruined and destroyed multiple lives in this. She's made a bunch of false accusations, went to CPS, And I have a lot of proof. She's dealing with a lot of substance issues herself. She loves shrooms. And it's just so crazy. I'm on 63 days without seeing my daughter. If anything, I need a protection order from her. I'm trying to go over all the allegations right here, but I did go to their parents' house one time. I rang the doorbell. Her mom and them have always been so racist to me because of my ethnicity and my American bullies. They think that the pit bulls are going to eat them or something. And so her mom saw me at the door. She locked it. And so I just walked back to my car. Her dad came out. And I just said, for the last 7 years, as long as I've known your daughter, from my mom pulling her off a bridge from suicide attempts to anything, all I've ever did is love your daughter. If I've ever hurt her, like not physically, but emotionally, it's never been intentional. And I just said, I hope you guys are blessed. I never cussed at them. I never was aggressive to them. As far as her sister, I've never texted her sister except what she had mentioned maybe twice to ask her to let me speak with Kenya. Um, if anything, I did make threats. It was to her boyfriend, and I told her like he can't come in the cul-de-sac because he was choking her out, and her parents allow him to do that in their house and have sex in their house, but I can't come nowhere near the house. It's a problem if a black man comes near the house. And basically, all this stems from me giving her an STD and her just being messed up on substances. And I haven't, like I said, seen my daughter in 63 days. I don't know what she did for the first day of school. She's missing basketball, gymnastics, and then her going out of her way. She went on my daughter's tablet to get my daughter's mom's number. And this is the third time, and it's like 3 strikes, you're out. Every time that she did that, it resulted in something bad. My daughter's mom like physically assaulted her when trying to serve court paperwork to her for our parenting plan. And this is all a ruse too. This has my daughter's mom written all over it. Like Kenya isn't the sharpest tool in the box. She has I believe she means well when she does some things, but she doesn't even know what a protection order is. And that's just the number one play out of my daughter's mom's handbook. And it's to have my mom involved in this when my mom has done so much for her, more than her own parents, is just crazy. Like she has me right now parked on the side of the road. I'm in Florida helping with the Milton recovery effort with my family. And like I said, it's really at the end of the day impacting my daughter directly. I'm the only consistent thing my daughter's ever had in her life. And she should worry about her own family and her own problems before doing any of this, because she way overstepped her boundaries with no legitimate reason. And that's really all this. I just asked that she drop the protection order. As far as her saying I only come over there to mess with her, we've been at that residence since 1993. My dogs are located there. My dad is battling prostate cancer right now. So I go over there to help him and take care of my dogs. And so, yeah, I don't know. I don't know the point or reason for any of this except her being upset that I had given her STD. Because once that happened, then all of this crazy stuff started happening.
All right. Thank you, Devin. All right, Judith, would you like to add anything?
I would love to add. Where should I begin, Your Honor? Would you like to ask questions or probe any particular scenario or?
You're Devin's mom, right?
Absolutely, 100% biological son. We are related in that manner, Your Honor.
Okay. And I mean, do you have any personal knowledge of any of these interactions?
I do, very much intimate knowledge. I've embraced this for over 7 years, Your Honor.
And you support what your son was just telling me?
I do support most of what my son has stated. However, he did not include some of the most essential or critical elements to this case. And I have already made an intentional plan to request a motion to the court to sever these combined, or if you will, consolidated cases, for the simple and clear reason that I have no bone or issue or involvement in the matter of harassment. I simply happen to be a henpecked mom to Miss Kenya Ramos. I have very little knowledge of her sister, Miss Jessica Ramos, and have only interacted with her one time when she was invited to my home approximately 1.5 years ago by her sister, Kenya, and I met her and we had a very gracious introduction. However, some of the comments Miss Kenya Ramos has cited in her petition filed with the court, as well as her audio testimony given to the courts, I still have yet to be able to determine or understand how she was capable of persuading the courts through her urgent and compelling reasons or matters of harassment examples, because none of the examples that she has provided in her court testimony are accurate or have any merit to me or my namesake.
Well, I think I can get, kind of to the heart of what you're asking for here. And I kind of have the same concerns as I was listening to both Jessica and Kenya tell me, what was going on here in this relationship, what the basis was for asking for the anti-harassment order, what the harassment was that, led you to come to court and ask for that order. And while I can certainly understand the tension, in the relationship, and it sounds to me like the tension in the relationship goes out beyond just between, just in between Kenya and Devin, but out into your families. And there's obviously conflict that's going on there. None of this is legal harassment. And, when we say harassment in just ordinary conversation, just talking to each other, we mean something different than what the law defines as harassment. And being quarrelsome or being difficult or being nasty, those things aren't harassment. That's just people maybe with bad manners or with, maybe in some cases, even if, like what you said, bringing up things like immigration status and racial issues, those are sometimes really hurtful things to say to people, and they're maybe reprehensible even, but in the context that they've been offered here, they don't constitute harassment. They might in other kinds of contexts, but not what's been described here. So I haven't been offered any basis, a legally sufficient basis to issue an anti-harassment order in either of your cases against either of these two respondents. So just the evidence is just not there. Now, conflict is there. I get it. I understand you have described that there's a bad, broken down relationship that has resulted in there being conflict, and there have been, as a result of that, some unpleasant things said, but that I can't issue an order for. Okay. So I'm sorry that it doesn't bring you any help, but that's how I see the application of the law here.
And Your Honor, I forgot to mention one thing too. If Kenya was so concerned with all the harassment, I got a text from her and multiple phone calls. I believe it was Thursday or Friday night, and it was just adding more to my stress. Like, I would say the harassment is more coming from them because I have nothing to her. And so for her to call me and say she loves me and all this other stuff, it's just, I didn't know it was her because she never said it was her. I had to pay to do a number search and try to report it to the Thurston County Sheriff Department to support it in this case. But I just wanted to add that as well. Like, if she was so concerned, she wouldn't be reaching out to me telling me she loves me.
All right. Well, you won't have to worry about the order now. The temporary order that was previously issued is expired and over now, and there is not a new order issued in any of these 4 petitions. So
Your Honor,
Thank you, Your Honor.
May I address the court?
Sure.
Thank you. Very brief. I wanted to state that due to Devin receiving multiple text message and phone calls from mystery persons or persons, I contacted the local jurisdiction in the state of Florida where he's currently living to ask that they investigate the communication of harassment by electronic medium. Whoever is harassing my son, Devin Hart, obviously knows and has very intimate knowledge of his personal predicaments and what he's currently facing with both the civil and the family law courts. And I have made every effort to amicably resolve, to stay away, live our life as we choose to. I don't care about her parents' immigration status.
But we don't need to go into this.
That's all I have to say. That was brief, Your Honor.
Okay. All
Yes,
right.
Your
So
Honor.
that will conclude the hearing for today. All right.
Yes, Your
Thank you,
Honor.
everybody. I think I see Miss Mallenbry
Thank you, Your
has joined us.
Thank you, Devin.
Yes, I was unable to unmute it before for some reason when you called my name.
Okay.
Sorry.
Well, we'll go back to your case now. And this is your petition against Jesse James Brown. This is number 24-325. And Jesse Brown did not answer the call to calendar. What I wanted to do here is to that's the issue of whether the notice of the hearing and the temporary and the petition were served on Mr. Brown.
I have the copy of the service right here, and I believe it was filed with the court. I don't know what day, to tell you the truth, that I took it up there last.
Because I saw it earlier, but I'm not seeing it now. Don't know why. What's the date on it? Oh, it's not showing up in my file.
Yes, I haven't found it.
Okay.
It says unable to find subject.
Yeah, she filed a proof of service though. I'm relatively certain she filed a proof of service that I did see previously, and now I don't see it.
I did last Monday. I'm looking at it, but it doesn't help you.
Ah, here we go. I think I found it. No, no, that's not it either. No, I saw it in there. Yeah, no, yeah, can you take that outside, please? You take that outside, please?
Yeah, sorry.
And your return of service was not from the sheriff's office, right? It was from a process server?
Yes, correct. The sheriff's office
Okay.
couldn't find him because he's moved to Seattle to avoid being served. So we had to hire, myself and another woman who was trying to serve him, had to hire a process service to find him.
Yeah, do you recall? Oh, wait a minute. May have found it. But there was an actual written declaration in here by a process server who described serving him. And if I remember right, he did it in Seattle.
That is correct.
Yeah, so I know I've seen the document. Is there a way, I hate to, oh, here we go. Here it is. It's in her exhibits. There it is. It was filed on October 28th. So yes, now I've got the affidavit of the service that was filed. Okay. Yep, I do have it in her group of exhibits. Yeah, it came in with the exhibits and it was filed with them, but yeah. Okay. All right. Yeah, I'm satisfied then that there's been appropriate service on Jesse James Brown. So there being no response from Jesse James Brown, I will issue the protection order, the anti-harassment order by default.
And I have a question, Judge.
Mm-hmm. Yes.
Could you please make Seattle Police and Thurston County Sheriffs to serve it? Because I don't know.
It doesn't need to be served any further.
Oh, okay.
It's been served adequately. So that's all that needs to happen.
Oh, okay. Thank you. So then he doesn't need to be served the permanent one?
No.
Okay, thank you.
I do need to do is make sure that the orders match. All right, Ms. Mellembry, I have extended your anti-harassment order for a year.
Thank you.
You're welcome.
May I leave now?
Yeah, you absolutely can.
Thank you. Have a good day.
You too. All right, and I'll call that addresses all the matters that were on the calendar.
I was supposed to appear today too. And I'm Joanne Brackett. I was supposed to be here at 9:30. And I think my case was dismissed, but I wanted the paperwork.
You're probably in the wrong courtroom, so it's probably either courtroom 1 or 2.
That's not what they told me when I went and checked in. What, this is 2, right?
This is
3.
3. Okay, so where am I supposed to be? 2 is, did you say 1 or 2?
1 or 2.